morning.
Are you gonna do the master of ceremony or should I?
You do it. Yeah, you do it.
Okay. You'll keep your laptop with your speech.
Yeah.
Oh, I love the desktop higher.
The what, sorry?
I like the design of the like screen.
Yeah. Okay, ladies and gentlemen, if you can take your seats, s'il vous plaît. Good morning. Miroslava, how are you? I'm just waiting till everyone takes their seats. The presentation today will be in English and Ukrainian, so please make sure to get headsets if you don't speak one of these languages. I'm so happy to see such a good turnout. This is great. Erdita. No, I'm fine. Yeah. People are still finding seats, so I'll just wait a little bit more just to, okay. We just have Dominika, you have to find a seat. Okay, so welcome everyone. Everyone set? Headsets, ready to go? Okay. So welcome everyone. Let me begin by thanking our partners, the Registry for Damages for Ukraine, otherwise known as RD4U, including the wonderful Executive Director, Markian, and his colleagues. RD4U and the International Commission on Missing Persons have co-organized this morning's roundtable. Let me also thank our panelists, many of whom have made the long journey from Ukraine. Some of them are here. This includes representatives from the Ukrainian government and the Ukrainian civil society, as well as international experts from around the world. I would also like to acknowledge the generous support of the Netherlands, Norway, and Canada, who have funded this roundtable, and the Netherlands, Norway, Canada, Germany, and the United States, who are supporting ICMP's Ukraine program. I hope that by exchanging ideas today on the issue of reparations for families of the missing, we will be able to support the families and help them access their rights. This roundtable is the fourth in a series that ICMP has hosted on Ukraine since May 2024. The first meeting in Kyiv focused on interinstitutional cooperation to account for missing persons. The second in Warsaw took the form of a technical workshop on advanced scientific methods to identify missing persons and the circumstances of their disappearance. The third roundtable in The Hague examined the issue of children who have gone missing as a result of the Russian invasion, including those illegally deported to Russia. There will be another event in June in The Hague on the topic of missing persons and accountability, and I would welcome you all to come to that event as well. The purpose of these events is to highlight the extraordinary measures Ukraine is undertaking to build a capacity to find a huge and growing number of missing persons and to secure the human rights of families of the missing while fighting a devastating war. Today's roundtable comes at a very important time. Hold on, I just went too fast here. Today's roundtable comes at a pivotal moment. On the 12th of March, RD4U opened category A2.2, a claim category that enables individuals whose immediate family members have gone missing due to Russia's full-scale invasion to seek compensation for the anguish they have experienced as a result of the disappearance of their loved ones. This represents a significant step forward for Ukraine that could serve as a model for many other countries around the world. Victims have fundamental rights to reparation, which encompasses measures to redress violations of human rights through a range of material and symbolic benefits. Reparations must be adequate, effective, prompt, and proportionate to the gravity of the violations and the harm suffered. The establishment of claims category A2.2 is essential. No compensation can erase the pain of loss, but this process offers a pathway towards acknowledgement and redress. The establishment of RD4U is precedent-setting. There are challenges that need to be addressed, however, and one of these challenges is the fact that families of the missing can only register claims if their relatives disappeared in Ukraine on or after 24 February 2022. This raises critical questions about those whose loved ones went missing in the period from 2014 to 23 February 2022, and this is something RD4U is striving to address. Additionally, while RD4U serves as a vital record of claims, it is not a claims commission or a compensation fund, and it will not evaluate claims or order payments. These responsibilities will fall to an international compensation mechanism, which is yet to be established, and uncertainty persists regarding the resources for funding this mechanism. In addition to addressing the issue of compensation for mental anguish, today's roundtable will also explore how families can access their other rights in the context of indeterminate loss. Under the current legal framework in Ukraine, relatives must obtain a death certificate to access certain rights. This can hinder families of missing persons from accessing rights in fields such as social welfare, financial matters, family law, and property rights. It entails a significant emotional burden. It requires that families prove before the court that their loved ones are deceased, despite the uncertainty surrounding their fate. Countries such as Bosnia-Herzegovina and Sri Lanka, which have faced similar challenges, have introduced something called certificates of absence, reflecting a more victim-centered approach, and important lessons can be learned from these examples. Despite its legal validity, the application of the certificate of absence in Sri Lanka has not been widely accepted by financial institutions. This has led to complications, particularly in cases where missing persons had significant deposits or multiple claimants to their assets. In Bosnia-Herzegovina, the certificate of absence can be characterized as a success. To date, the Missing Persons Institute has issued more than 2,600 certificates of absence to family members, and this has enabled families to regulate issues related to property rights, inheritance, employment, and family law. ICMP encourages the government of Ukraine, in dialogue with families and civil society organizations, to consider the creation of a legal status of absent, which would then make it possible to issue certificates of absence. This would empower families to exercise their rights, and at the same time, it would ensure that state maintains its obligation to investigate missing persons. Since a majority of those who are missing as a result of the Russian invasion are men, certificates of absence would provide much-needed support to women who constitute the preponderance of survivors. I look forward to today's discussion about measures that can help bring about significant change for hundreds of thousands of families of the missing whose lives have been irrevocably changed as a result of this war. Thank you.
Thank you, Catherine. I'd like to invite Mr. Markian Klitschkovsky, Executive Director of Register of Damage Caused by the Aggression of the Russian Federation against Ukraine, to take the floor. Markian.
Good morning, ladies and gentlemen. Thank you all for being here in person and online for this roundtable on reparations for missing persons for Ukraine. I am very honored that the Register of Damage can co-organize and co-open this event together with our friends from ICMP, and thank you very much, Catherine, for your warm words in your introduction. This roundtable comes at a pivotal moment. We are here because of an immense and ongoing tragedy, the war that for more than 3 years now has brought grave consequences and shattered lives of thousands, if not millions, of people across Ukraine. Among its many devastating events and effects is the disappearance of thousands of individuals that stands out as one of the most painful and unresolved dimensions. Each of these missing persons represents not only a profound individual loss, but a wound that is left open, aching with uncertainty for their families, for their communities, and for the country as a whole. The Register of Damage for Ukraine was created as a cornerstone of international effort to ensure that Ukraine receives fair and just reparation for all the harm inflicted by this war. Our work is rooted in international law and aligned with the principles of justice, accountability, and human dignity. The right to reparation is not a theoretical one, it is a lived necessity for victims and survivors. And that right extends to those affected by the disappearance of their loved ones. This is why the Register of Damage established a category for claims related to disappearance of family members, category known as A22, that we opened just a few weeks ago for submission of claims. It filled a critical gap in the reparations framework, ensuring that the distinct experience of families of the missing persons is recognized and addressed. It acknowledges a particular kind of suffering, the agony of not knowing. When a loved one is missing, there is no closure, no finality, only silence, hope, and fear that sometimes is carried over years. Throughout this claims category, the Register of Damage seeks to ensure that those who bear this indefinite burden are not forgotten in the legal and moral architecture for reparations that is being built. They are at its very heart. In the short time since the category was opened, we have already received almost 2,500 claims from family members of the missing persons. An extraordinary response that reflects both the urgency of this issue and the deep, widespread pain experienced by the families across Ukraine. The sad truth is that we know that that number is much higher than that. The registry of persons missing under special circumstances in Ukraine has more than 50,000 records of people whose whereabouts are unknown, and all these are the people who we seek to help. We are working closely with the Ukrainian institutions to make this possible. I would especially like to recognize our cooperation with the Ministry of Internal Affairs and the Commissioner for the Missing Persons, Mr. Dobroserdov. Thank you very much for your ongoing work. Our integration in a literal electronic sense with the Registry of Missing Persons under Special Circumstances highlights its role in verifying the fate and status of missing persons, is fundamental to the integrity and success of this process, including by providing essential evidence to claimants seeking reparation under this category. We are also extremely grateful for our deep and effective partnership with the ICMP. ICMP's work on the ground in Ukraine, in the region, and throughout the world has been absolutely indispensable. We commend ICMP for its tireless work, for its unwavering commitment for truth, accountability, and support of victims and their families. We're honored to be able to work with ICMP in this crucial mission. This work would not be possible without many other partners. I would like to express my sincere gratitude to the governments of the Netherlands, Canada, Norway, and many others that consistently and strongly support this effort. Of course, reparations must be fair and efficient. RD4U is a tool that collects the claims and serves as acknowledgement of the pain and suffering of the victims of the war, but it is not enough. This is why we're already now working towards the establishment of a claims commission, a second pillar of the comprehensive compensation mechanism for Ukraine. which will ultimately decide on the claims submitted to RD4U and determine the amount of compensation, the amount of reparation due in each individual case. It will do so in an impartial and a transparent way. Last week in The Hague, negotiations for a treaty to establish a claims commission for Ukraine officially began, with participation of 55 delegations from across the world. We hope and expect that the treaty will be concluded before the end of this year, and the commission that will merge with the Register of Damage will commence its work in 2026. Today's event, today's roundtable, is part of that path. Together with experts, institutions, and families, we are shaping the mechanisms that will help address one of the most difficult and painful legacies of this war. Thank you again to our friends at ICMP, to our Ukrainian and international partners, and above all, to the families and communities who continue to search for answers and demonstrate incredible resilience in the most difficult circumstances. RD4U is here to serve you, and we will not rest until your rights are recognized and your losses are acknowledged. Thank you.
Now we will hear two video messages from distinguished speakers. The first one will be from Mr. Bernard Duhaime, United Nations Special Rapporteur on the promotion of truth, justice, reparations, and guarantees of non-recurrence, immediately followed by a video message by Mrs. Daria Marchak, First Deputy Minister at the Ministry of Social Policy of Ukraine. Can we play the videos now? Thank you.
Good morning. It's a pleasure to speak with you today. Although I regret not being able to join you in person, I'm currently undertaking a country visit in Brazil. I recently entered my role as Special Rapporteur on the promotion of truth, justice, reparations, and guarantees of non-recurrence, and the opportunity to participate in discussions like this is invaluable as I decide how to best pursue the aims of this mandate. Therefore, I want to take a moment to express my gratitude to the organizers of this expert roundtable on reparations and missing persons in the Ukraine. Allow me to begin by recalling the foundational pillars of my mandate. Firstly, the right to truth, the right of victims and their families to know the truth about the perpetration of human rights violations and the circumstances and reasons that led to them is inalienable. The full and effective exercise of the right to the truth is also an essential guarantee against the recurrence of violations. With regards to justice, states have an obligation to investigate and punish serious human rights violations such as torture, extrajudicial executions, and enforced disappearances. Failure to effectively investigate and prosecute such violations is in itself a violation of human rights treaty norms and may be an important factor contributing to the recurrence of violations. Third, reparations. Victims have the right to receive adequate, effective, and prompt reparation for the harm suffered. Victims must also have access to relevant information on reparation mechanisms, and I will expand on this point shortly. Fourth, memorialization. Memorialization of serious human rights violation is essential in transitional justice processes. Without memorialization, the rights to truth, justice, and reparation will not be fully realized, and there will be no guarantees of non-recurrence. Talking of which, to ensure that past violations are not repeated, strategies must be developed to undertake institutional reform and other measures necessary to ensure respect for the rule of law, to foster and maintain a culture of respect for human rights, and to restore or establish public confidence in government institutions. Now, returning to the issue of reparations, I would like to emphasize the legal obligations of states in this regard. In situations involving serious violations of human rights and international humanitarian law, states are required to provide victims with reparations that are accessible, prompt, and effective. This obligation is grounded in the broader duty of states to offer remedies to victims of human rights violations and breaches of international humanitarian law. The basic principles and guidelines on the rights to a remedy and reparation for victims of gross violations of international human rights law and serious human rights violations of humanitarian law outline the core principles regarding reparations, and these have been increasingly adopted by international courts and human rights mechanisms. These guidelines have been increasingly adopted also by domestic courts. A significant body of jurisprudence has emerged over time, underscoring the importance of this right. States must ensure that reparations are not only symbolic, but are also implemented through both judicial means and special programs designed to provide tangible remedies for victims. These programs may be established through administrative and legislative action, often supported by national or international funding. The scope of reparations should be comprehensive, addressing all harm and be proportional to the gravity of violations and the suffering caused. For the right to reparation to be fully realized, it is crucial that the state, along with other relevant actors, acknowledges its responsibility for the violations. I would like to emphasize that judicial approaches to reparations generally focus on the principle of restitutio in integrum, the restoration of victims to the position they would have been in had the violations not occurred. This principle means that reparations must encompass a range of measures, including compensation, restitution, rehabilitation, satisfaction, and guarantees of non-repetition. Finally, the state's obligation to provide reparations is not just a matter of fulfilling a legal duty. It is an essential step in fostering, healing, restoring dignity, and preventing the recurrence of such violations. States must take these obligations seriously, not only as a matter of legal compliance, but also as a moral imperative for the reconciliation of societies that have been torn apart by human rights violations. To conclude, I would like to take this opportunity to highlight the significance of the work done by the Register of Damage for Ukraine and to commend the opening of category A2.2 for claims related to missing persons. This is a meaningful step forward, and I look forward to closely following the progress in this area. I hope that today's discussions will further contribute to our collective understanding of the critical importance of reparations in the context of the ongoing challenges in Ukraine. Thank you once again for inviting me to speak, and I look forward to future conversation on these important issues. I wish you all a productive and insightful day ahead.
Доброго дня, шановні учасники експертного столу. Шляхи
Good morning, dear participants of the roundtable on the matters of reparation and legal remedies. This is a very important topic for us as the Ministry of Social Policy of Ukraine, especially today when, according to the data of the Ministry of the Interior, we have more than 63,000 missing people who went missing in special circumstances. It is quite obvious that one of the categories of citizens that need our help most, those are families of the missing. Those are the families that suffer mentally, but also they have lost their breadwinners. Therefore, for us, it is very important to support such families. Despite the fact that we are facing this difficulty, we understand that ultimate responsibility is to be shouldered by the aggressor state, but we need to help our families now. That is why we, as the Ministry of Social Policy, we are providing for different support mechanisms. We provide for psychological, psychosocial help to the families, which is being delivered through our network of centers of resilience. Also, many families have lost their breadwinners. Therefore, we need to help those families in the form and shape of allowances. Therefore, we are offering them allowances for educational services and for housing services. However, we understand that psychological and financial help will not help us to alleviate the pain and suffering that those families are undergoing because of the loss. That is why every single family of every single person who went missing should receive reparations from the aggressor state, and we welcome that the International Register of Losses has opened up a new category, that is the possibility to submit claims in the case of the missing relatives. This is exactly the type of loss that has led to so much suffering. We, as the government, understand that we need to understand every single person who have lost his or her close one. We need to help them with all the documentation so as to be able to verify and to provide the International Register of Laws with all the information that will codify such losses. Recently, the Parliament of Ukraine passed a law already signed by the President, that is the law on the losses inflicted on Ukrainian citizens by the Russian Federation. So we will collect all information and evidence necessary so as to be submitted to the International Register of Losses without the repeat traumatization of our citizens. We would like to thank the international community. We would like to thank all those who have joined this International Register of Losses. Thank you for fighting for the rights of our citizens, for compensation and reparations for the suffering and pain they have been inflicted upon. I would like to thank you for this meeting, and I wish you a very fruitful meeting. Thank you.
I'd like to thank the speakers that have sent their messages through video. Now I invite Mr. Anatoly Solovey, Deputy Head of Mission at the Embassy of Ukraine in the Netherlands, to deliver his remarks. Mr. Solovey.
Excellencies, distinguished guests, dear friends, good morning. Thank you for joining us this morning. Please let me thank to all previous speakers for warm, encouraging words about Ukraine, about our struggle. Please let me also extend our sincerest gratitudes on our partners from the ICMP, from Dutch Ministry of Foreign Affairs, from Norway, from Canada, from many, many other friendly countries for their commitment to address the issue of missing persons in Ukraine. As you know, since the beginning of the war in 2014, and more recently, since the beginning of full-scale invasion in 2022, Ukraine has suffered not only the loss of lives, but also a staggering number of missing persons. For us, these persons represent much more than just names in a long list. They are beloved family members and friends whose absence leaves deep wound, deep void in our hearts and minds. Justice for victims and return of the missing, reparations to those who sustained damage are key priorities of Ukraine's pursuit of accountability. The path to reparations for the missing persons is full of challenges. First of all, legal and institutional. We are here today to discuss those challenges and explore the ways towards meaningful reparations. Today, we will hear the representatives of Register of Damage, many stakeholders of this process. With the support of Dutch government, the register has been fully operational since April 2024. Together with our partners, we are committed to establish the Claims Commission for Ukraine as soon as possible. After the register, it will be the second integral element of the international compensation mechanism. It will examine the claims submitted to the register and determine the compensation amounts to be paid to the victims. At the same time, we are actively engaged in resolving the most difficult issue, the source of filling the compensation mechanism with necessary money. Our strategic goal here is to make Russia pay for all horrible crimes they have committed in Ukraine, including the loss of lives, destroyed property, damaged nature. The third crucial element of the compensation mechanism should be the compensation fund, which is planned to be filled at the expense of $300 billion of frozen assets of Russian central bank. It can cover not everything, but a good half of the amount of losses, which are assessed by today as $589 billion of American dollars. This is just for 3 years of full-scale invasion. I'm not even mentioning the damage inflicted to Ukraine since the beginning of the war, as I said, in 2014. We deeply appreciate our close cooperation with the International Commission of Missing Persons. Through such partnerships, we aim to strengthen our legal responses and ensure that the voices of victims and their families are heard and acted upon. I look forward to the fruitful discussion today, and I hope that together we can take meaningful steps forward to ensure that reparations, justice, and peace are no longer just aspirations, but realities for those whose loved ones are still missing. Thank you once again for your participation and for your unwavering support and commitment. Thank you very much.
I'm pleased to invite now His Excellency Erling Rimestad, Ambassador of Norway in the Netherlands.
Excellencies, distinguished participants, Norway's support program for Ukraine, the Nansen program, is a multi-year military and civilian support program. Last month, all parties in the Norwegian Parliament agreed to significantly increase the support for Ukraine for 2025. Our total support for Ukraine now amounts to approximately 19 billion euro for the 8-year program period. We aim to quickly gear up our support for artillery ammunition, drone capacity, investment in Ukraine's own defense industry, and for financial and humanitarian support. Globally, we continue to support a range of initiatives and partners working on issues related to human rights, democracy, governance, and anti-corruption. This includes the Council of Europe, UN High Commissioner for Human Rights, UN Women, OECD, and also the ICMP. More than ever, international support for such initiatives is needed. Norway is ICMP's largest contributor in Ukraine. We have entered into a multi-year agreement with the ICMP, providing Norwegian kroner 100 million for the period 2023 to 2026. We are actively engaged in the international discussions on accountability mechanisms and compensation for the victims of Russia's war. There is positive momentum in both the core group and the crime of aggressions, and the discussions on establishing a claims commission as the second component of a compensation mechanism. This demonstrates determination and resolve from the parties involved. Combating impunity for international crimes is a foreign policy priority for Norway. The Independent International Commission of Inquiry on Ukraine has played a key role in documenting the extensive violations of international humanitarian law and international human rights law during Russia's war against Ukraine. While Ukraine largely complies with its obligations, there is now extensive documentation of Russia's violations. The documentation is supported by reports from the UN Human Rights Monitoring Mission in Ukraine and the OSCE Moscow Mechanism mission of experts. Thousands of Ukrainians, both military personnel and civilians, are likely being held in captivity in Russia and in occupied areas. As the Independent International Commission of Inquiry on Ukraine highlighted in its latest report, Russian authorities have systematically failed to provide information on their whereabouts. This constitutes a clear violation of international law. The report highlights that Russia's widespread use of enforced disappearances in occupied Ukraine has targeted civilians, including local officials, journalists, and others perceived as threats, with many subjected to detention, torture, and forced transfers. Together with Ukraine and Canada, Norway is proud to be co-leading Working Group 4 of Ukraine's peace formula on release of all prisoners and deportees. The so-called human rights dimension of the peace formula is central to any peace process and has re-emerged as of strategic interest also for the US, while of course being an ongoing priority for Ukraine. To build trust between the parties will be hard, but prisoners of war exchanges and potentially the return of children and civilians remain a key area where trust could be rebuilt, albeit slowly, through direct contact between Ukraine and Russia. I would like to thank you so much for the invitation to this event. We look forward to our continued cooperation, and we are very much impressed by the efforts made by the ICMP. Thank you very much.
Thank you, Ambassador. I now invite Mr. Christopher Yu from the Embassy of Canada in the Netherlands.
Excellencies, Director General Catherine, Executive Director Mark-Jan, distinguished ambassadors, dear legal advisor colleagues, my friends. Canada is a supporter and has long been a supporter of the ICMP's work. And in connection with this project in particular, Canada was pleased to support the ICMP with a project grant in the amount of 3.3 million Canadian dollars. This project supports Ukrainian authorities in locating missing persons following Russia's aggressive invasion of Ukraine. The funds have empowered ICMP to assist in identifying victims and supporting exhumations to judicial standards of evidence. And there are a lot of activities under the umbrella of this project. This includes helping families of the missing so they understand and are engaged in the process to find and identify their missing relatives. Another activity empowering families of the missing to secure their rights to truth, justice, and reparations. And through this project, we expect many meaningful and fruitful outcomes. For example, one, the increased ability by the Ukrainian governmental authorities to investigate cases of missing persons, including mass and clandestine graves, to appropriate judicial standards. And another one, increased awareness by the families of missing persons and civil society organizations of their rights and obligations as part of their active participation in the missing persons process. I mentioned investigating to judicial standards several times in my remarks just now, and I think it is important in the City of Peace and Justice, which is the cradle to so many international courts and tribunals, to reflect a little bit on what this means. I myself, as someone who has had the privilege to work at the ICTY, IRMCT, ECCC Cambodia, and the ICJ, can very much understand that evidence must meet international standards so they can withstand scrutiny and for justice to be served. And a little remark on The Hague, since Executive Director Markian just mentioned. Canada was, of course, very proud to co-facilitate in the UNGA 77 session, the original resolution that set the framework for this three-step endeavor. And this three-step endeavor, as many of you might know, comprises of the Register of Damages, the Claims Commission, and a future potential compensation mechanism. As many of you are aware, if you joined the discussions last week, Canada does not have a mandate yet, but we'll be very happy to engage very actively to make this project a success. Lastly, I wanted to touch on one aspect of missing persons, and that is children. Canada is particularly committed to protecting the best interests of children, reuniting children with their families, supporting the return and integration, and ensuring that these actions do not happen again. This is why we co-chair, along with Ukraine, the Coalition for the Return of Ukrainian Children. And to date, 41 countries have joined this coalition. We do hope that all missing persons, children, brothers and sisters, husbands, wives, colleagues, can be located, identified, or returned, so families and communities can have proper closure in this unfortunate aggressive war by Russia. I thank you.
I would like to invite now Mr. Bart Pans from the Ministry of Foreign Affairs of the Netherlands to share his remarks.
Excellencies, also a few words of welcome from the Netherlands, host country. Thank you for your kind words about The Hague being the city of peace and justice, international peace and justice. Always nice to hear that from others than from ourselves, so thank you. Yes, from our side, I think this is a very unique initiative that brings two organizations together, the ICMP and the Register of Damages. And I think with the international legal order under increasing pressures, we need these kind of synergies and collaborative initiatives. And we also obviously need really strong attention for justice and accountability, because it is in the end the spine of the international legal order. And I really like the big turnout today, because keeping that spine up depends on all your motivated individual efforts, but also of your countries and your organizations. And in these challenging times, we really need more of that for the people of Ukraine, obviously, but also for the broader collective aim of upholding this international legal order. So I really want to bring that to that level, because I think all of our efforts today contribute to that collective aim. On today's event, I'm very happy that the team that I lead in the Ministry of Foreign Affairs covers both organizations. The Netherlands is a founding partner of ICMP and has provided a contribution of €2 million to the program for finding the mission in Ukraine. My division is also responsible for accountability for Ukraine, including for helping, obviously we heard a lot about it already, the establishment of a compensation mechanism for damage caused by the aggression of the Russian Federation against Ukraine. And beyond our role as a host country of the Register of Damages, we are committed to hosting a future fully fledged compensation mechanism you heard a lot about as well. As a next step in this, as many of you will know, the Netherlands is currently chairing the international negotiations on the modalities for setting up a claims commission. As we've heard before, many speakers, the timing of this event is really well chosen because on 11th of March, the Register of Damages opened category A 2.2. We'll not get into those details because everyone before me did that already, but I just really want to highlight that from our perspective, the importance of compensation cannot be overstated. It's really an essential part of the victim-centered approach that we think should be a key part of all justice and accountability efforts. And I really hope that today's event will contribute to that. And of course, more specifically, the important objective of awareness for family members of the missing purpose, of their rights, and the possibility to submit claims with the Register of Damages. So I think that hopefully, and many are highlighted, will be the outcome of today's event. And I'm really sure that the panel can help clarify many of the questions and concerns that families and victims will have regarding the submission of claims to the Register. And of course, I hope that policymakers from Ukraine and globally can learn from practical challenges families are facing in claiming their rights. Let me conclude. As the only organization with a mandate specifically addressing the issue of missing persons, ICMP has a key role in global discussions on compensations in cases of missing persons and enforced disappearances. It's really therefore crucial that ICMP and the Register of Damage cooperate effectively in this area. And I can assure you that from our side, we're very keen to continue to support that collaboration and that collective effort. And let me end again with the point that I started with, really to get justice and accountability for the people of Ukraine, but also to collectively uphold the international legal order. Because without a victim-centered approach to justice and accountability, things will go downhill very fast. But that's a too pessimistic note. We are here today to really achieve something. So thank you very much for your attention, and I wish you a really fruitful event.
Well, that wraps up the opening session. I'd like to thank all of our speakers. And would have the pleasure now to invite our panel moderator, Ms. Katarina Rashevska, and all the panelists to take their seats at the stage, and I give the floor to Katarina. Thank you.
Please. So speakers, please take your seats. Distinguished audience, ladies and gentlemen, welcome everyone to our expert panel discussion, Pathways to Reparations for Missing Persons in Ukraine. My name is Katarina Rashevska. I am a legal expert at the Ukrainian non-governmental organization Regional Center for Human Rights, and today I will be the moderator of our discussion. Our goal is to gain valuable insights from our esteemed panelists and also identify challenges, opportunities, and I really hope actionable steps in order to guarantee the reparations for missing persons and their families, and also to try to gain justice for all of them. I am sure that our discussion will be meaningful and fruitful because of our distinguished panelists. They are all experts in their spheres. I would like to introduce all of them. So Ms. Katarina Pisotska, Mr. Artur Dobroserdov, Dr. Grazina Baranovska, Dr. Yasminka Jumhur, Ms. Franziska Eckelmans, Ms. Tetiana Katrichenko, and Ms. Alena Lunyova. Thousands of people have lost track of their relatives during the Russian aggression against Ukraine. Their relatives may have been killed or wounded. Their bodies may have been thrown into unmarked graves. They may have been captured incommunicado, or they may be held in custody without any notification to their family members. They may be also children separated from their families and then unlawfully deported or forcibly transferred. The plight of persons who disappear is tragic. So too is that of their family members. When a family member goes missing, it causes significant distress for all his or her relatives. Many spend years and their life savings searching fruitlessly for their husbands, wives, children, and parents. Besides the emotional sufferings, it may be financially crippling. Accompanying family members in their search for the missing persons and helping them to cope with the various difficulties their situation presents is vitally important. That is why a number of bodies and also individuals are involved in these activities, not only in Ukraine, but also in the international level. This is a particularly challenging task because it often requires actions on many levels. However, as we see, many relatives of the missing persons in Ukraine are now trying to use all means and procedures in order to find the information about their loved one's fate. That is why they should be in a position to decide whether they would like to have some support or they don't need this support, including specialized assistance, having access to all necessary services and resources. Of course, responsibility for enacting all relevant international provisions rests mainly on national authorities. However, international organizations such as the International Commission for Missing Persons and also, of course, International Register of Damage for Ukraine are also involved in this process and play, of course, crucial role, which we will discuss today without any further delay with our esteemed panelists. And our first speaker will be Dr. Grazina Baranovska, who will shed the light to a very important distinction between different definitions, including missing persons, but also people who were subjected to enforced disappearance, because as far as I know, it may have some impact on the legal situation of the affected persons, so it is really important. And also, of course, taking into account your professional experience, I would like to ask you to elaborate on how the working group on enforced and involuntary disappearances addresses the issue of missing persons in Ukraine. And of course, Dr. Grazina Baranovska, she is professor of human rights at the Friedrich Alexander Universität Erlangen-Nuremberg and the member of the already mentioned United Nations Working Group of Enforced Disappearances.
Wonderful. Thank you for the introduction to this panel, and it's really an honor to be on this panel with all of you and on this event. So the terms missing persons and enforced disappearances have been floated in this room in a lot of the talks already. And what I would like to firstly do is to shed light on those two terms and explain why this is relevant in the context of reparation. So some nuance with regard to those terms might be lost, and we can pick that up in the Q&A or during coffee. But to really kind of shed the light, I think that's really the important elements. So there is actually no international definition of missing person. So everyone that goes missing can be counted as such. In the context of armed conflict, as is the situation in Ukraine, the situation is a bit more legally defined, as international humanitarian law uses the term missing person without defining it, but we can assume that it applies to all persons that went missing because of armed conflict. So knowing that, we understand that missing persons under humanitarian law would actually apply to all persons that went missing in Ukraine since the beginning of the war, no matter the reasons for why they went missing. And this is really important because that makes it very different from enforced disappearances. So enforced disappearances, in contrast to missing persons, is actually defined in international law. And we have a number of definitions, and I will here engage with the human rights definition that's in the Convention and in Declaration, and not in the definition that we have in the Rome Statute. So according to the definition, 3 elements must be met. Firstly, the person must have been deprived at some point of their liberty. So it is, of course, possible the person has been deprived of the liberty and then effectively killed, but there needs to be this deprivation of liberty. Secondly, there needs to be an involvement of state actors, at least acquiescence of state actors. And thirdly, there needs to be a refusal to acknowledge this deprivation of liberty or a concealment of the fate and whereabouts of the person. And by listening to that definition, I'm sure in all of us, it rings a bell that so many people that we have heard about in Ukraine meet this very definition, right? They have been deprived of their liberty by Russian forces, and their fate and whereabouts is concealed. There's no acknowledgement of what has happened. So as such, we can consider people that are forcibly disappeared to be a category of missing person. It's a part of that. And there is a huge number of people that were forcibly disappeared in Ukraine. Why is this differentiating important in the context of reparation and international law? This is because only with regard to enforced disappearances, we have a very clear legal line that not only the victim, the disappeared person, but everyone who has suffered in the effect of the disappearance is a victim of an enforced disappearance. That means a man is forcibly disappeared by Russia, and his wife and his children and possibly his parents are also victims of enforced disappearance. It's not only the person that is effectively in the prison, it's also his or her family. That also means that the reparation that are legally obliged to be provided to the victims are to all of the victims, to the disappeared and to all that have suffered, that being mostly the family of the disappeared. So here we do have a very solid legal grounds to provide reparation. So what does it actually practically mean then for providing reparation? And here I would really call for caution in providing categories. As has been already pointed out in the introduction to the call, one of the things that we are struggling with, we might be struggling with, is we do know people went missing. We do know people were forcibly disappeared, also before February, before the full-scale invasion. We do know that that has happened. We do know that some people who might consider their loved ones to be forcibly disappeared, that those persons might not be forcibly disappeared. Do we believe that another legal or practical framework should apply for them? Let's imagine a Ukrainian woman who assumes her husband is in Russian custody. And in next year, it turns out he was never in Russian custody. He was buried by a building that fell down. So it was never a detention. He was never forcibly disappeared. Do we actually believe that she, who was searching for him, who suffered the whole situation, another practical and legal framework should apply to her? And my personal opinion is that I don't think that should apply differently. And this is actually what most countries do. So then the legal differentiation we have in international law does not have to be applied on domestic law, because what domestic law and also international mechanisms can do is raise what applies to other people, other missing persons, to the standards that are required with regard to enforced disappearances. And this would be really a practice to not categorize too much, to not make it too limited, but to open it up and use the framework to enforce disappearances to also apply to people that might not fit, for various reasons, this particular category. And I will not delve into the substantive rights and as well what it entails actually, that the right to reparation, because I'm sure that will be covered, and also not to the individual and collective aspects of that is all of reparations that should be provided also with regard to enforced disappearances. I will close up with a short comment on the working group on enforced and involuntary disappearances. And yesterday, when we met on a preparatory meeting, one of the first exchanges we had was, I've heard it called, well, this is the UN working group that does not have results. And to be honest, that is true, right? So our aim is to establish the fate and whereabouts of those that are brought to us. And we are not able to establish the fate and whereabouts of the Ukrainians that have been brought to us because the partner that we are supposed to cooperate with in that endeavor is not cooperating with us. So what our core mandate is what we would call the humanitarian mandate. It's when we act as a channel of communication between families and a state. So in that particular situation, we're acting as a channel of communication between Ukrainian families and the Russian state. And while the Russian state has responded to us during the first couple of months after the full-scale invasion, it has stopped. So we have not received responses for a while. However, we still register cases, and we still very regularly send out letters via official channels to the Russian Federation. And we all in the working group strongly believe that it still matters. And I would argue that it's mostly three reasons why it really still matters for us to regularly send not only new cases, but also reminders about old cases. Firstly, I'm a legal scholar and practitioner. I don't understand geopolitics, but for some reasons, countries surprisingly sometimes respond. We don't know why that happens. We don't know when to expect a response, but sometimes, magically, we do receive responses. So that's what we are really hoping and waiting for, and that's why it's worth to keep sending the lists and keep sending the reminders. Secondly, we report to the Human Rights Council and to the General Assembly. And there we can say, of all of the enforced disappearances that we have registered last year, the vast majority comes from Ukraine. Those are people that were forcibly disappeared by Russia. And this is something that we have repeated a number of times already in Geneva at the Human Rights Council and in the General Assembly in New York. And thirdly, this is a way to build up pressure with regard to states and other institutions that we cooperate with, where we try to understand their position and also bring the voices of the families that come to us. So families bring to us questions about the working of the ICRC, and as a body, we are able to meet with them and channel those communications, those questions, get some answers and bring them back to the families. And this is also a way where we can make this issue still up on the agenda and keep addressing that, even though, to be honest, we did so far not succeed in bringing information about the fate and whereabouts to most of the Ukrainian families.
Thank you, Dr. Baranovska. And what I found really important, just to repeat and to sum up, that the number of victims in the context of the missing persons is much more higher than the actual number of missing persons, because we should take into account also their family members. And also, what was really important, as a point about intersectionality of violence, we have already discussed it during our preparatory meetings, because sometimes we are talking about families who are also IDPs, for example, and where we have also members who suffered sexual or gender-based violence, or this family lost property in occupied territory, and that is why they have additional needs. And what we should highlight any time that the Russian Federation is not cooperating with some United Nations institutions. And I'm sure that as our esteemed panelist will also tell it and highlight it during her speech. But now I would like to welcome our second panelist, Mr. Artur Dobroserdov. He is a Commissioner for Persons Missing Under Special Circumstances in the Ministry of Internal Affairs of Ukraine. Dear Mr. Dobroserdov, could you elaborate on the role of international cooperation and coordination in supporting families of the missing persons? Because as Dr. Baranovska has already mentioned, so we have missing persons, we have their family members, and their needs are so huge that, of course, we need some international support, technical expertise, also financial support. And the other part of my question is related to how how can international frameworks and partnerships strengthen this process of providing assistance, and what lessons can be drawn from existing efforts to ensure that families receive the necessary legal and financial support. Thank you.
Доброго дня усім. Я дякую за запрошення.
Greetings to all of you. Thank you for this invitation. It's a great honor for me to be a participant in such a discussion. One of the main powers of the Commissioner is to interact with the relevant authorities of other countries and international organizations. Among the international organizations, the main partners are the ICMP, the ICRC, and Register of Damages for Ukraine. Together with our international partners, we have already implemented the series of interesting projects, and we are continuing to implement many other important projects. Today, we are talking in particular about the opening of the A2 category A2.2. Those are claims in relation to mental pain and anguish caused by the disappearance of an immediate family member after the beginning of full-scale invasion. This is a very important issue, and I am pleased that we have completed the legal and technical part of this project, and practically this part of the work is already implemented. As for some other international projects that we jointly are implementing. This year we are going to start the operations of the Unified Center for the identification of victims of military aggression. This will make it possible to involve the best experts, forensic scientists, specialists, international specialists in the practical work, and also the experience of our international partners. We can forward the agenda of multi-discipline experts, the people who have knowledge in the most difficult cases. We will have to conduct a lot of forensic expertise, so we would like to have a name of the perished people, of the military personnel that will never go back home. Our partners are actively supporting us in providing military units with kits for collecting and storing biological samples from military personnel. Today, more than 240,000 of such kits are already delivered to the Ministry of Defense, and I expect that soon biological samples will be taken from every serviceman who is directly involved in combat operation. This will help us in search operations. Much attention is paid to education, training, and provisions of the necessary equipment, material, and consumables to national expert institutions. It doesn't depend what kind of ministries they belong to. It could be Ministry of the Interior, Ministry of Justice, Ministry of Health. We already feel a huge professional support for our experts. Also, it is important that our partners work continuously to obtain and process biological samples from the relatives of missing persons who are abroad. This work is continuing for a long period of time, and this will help to identify the missing persons and deceased. So thank you very much for this. Also, conducting molecular genetic examination and criminal investigations where relatives have doubts about the results of the examination conducted in Ukraine of the people who are missing. Ukraine welcomes these opportunities where we will be able to support our results, and we are completely open, and it's very important we have this support and opportunity to convince the person yet again that all decisions taken were correct decisions, and there is a way to identify the missing person. Also, the next important step will be to introduce the unified electronic database in the national forensic system to record information of the results of examination of the body by experts. It's also important that we have ICMP experience and development that's integrated of IDMS database is very important. We have seen how it works. We do this with the help of our experts, and in my opinion, this project will finalized in the near future. We do have a register of missing person, forced disappearance, and under the specific circumstances, and we do need to work on there more to have more opportunities to identify the people. That's why I count that we will have joint projects in the future. For first using OSINT search for information on the whereabouts of missing persons in captivity. Unfortunately, the country, Russia, aggressing country, does not adhere to the international rules and regulation. Thanks to the Red Cross, we receive information only in 1 out of 10 cases. That's why for us it's very important to receive all possible information. Also, we will draft amendments to legislation that will speed up identification process. This is very interesting and important for us. In the near future, we are talking about creation of the expert groups that will work on this drafts. Then, conducting information campaigns and scaling up communication with families of missing persons and representatives of civil societies. We already have some video clips, and we need to work with the civil society, and we hope to implement this in the near future. Talking about the coordination powers, all functions, me as a responsible for this direction, I'm doing everything possible to comply with this basic coordination function. Coordination is one of the main managerial functions, the essence of which is to ensure the orderly interrelation and interaction between the participants in the process in order to achieve certain common goals. And also, it's good that we have the access to all international databases. It's very important because it helps us to have very important and clear information. It's also important to have a communication. We have done a lot to develop this function. We have created a hotline. We have the representatives in 11 regions. Myself, personally, I meet with people every and each Wednesday. We have a lot of communications via Telegram channel, the website, etc. Also, we will create the unified platform where we will provide all the information on missing persons. Also, certain functions that help us to implement our coordination potential. It's prepare the analytical materials, development of the system, participation in the development and drafting of legal acts, and creation of the experts group. Last year we have an event for activities of investigators and the newly created police stations regarding missing person. This year we pay more attention of the expert activities and identifications. In January we had such an event. The participants were the practicing experts, and this exchange of experience was very useful for everyone involved. Nowadays, and we have talked about it, and we will talk more about the rights on missing persons and relatives of missing persons. I would like to stress that based on our legislation, the state is obliged to do everything possible to find person. Talking about the person that perished under special circumstances, it's a difficult question. We also work about it, and we had develop the opportunities that the person has right to go to court and announce that the person that was considered missing is deceased. There are already some court decisions taken on these cases, and this would be not be the reason that the search for such a missing person will be stopped. It will be continued, even though maybe this person is deceased. Second moment, no one is forced to initiate this claim to the court. It is family's decision only. Talking about the military personnel, yes, it's possible, but we still didn't have not even one such a court decision. It is the right of person, the family, and also it is linked to the civilian life and humanitarian assistance. Right now, we work to make possible for notaries that based on our national legislation can have an access to this register. This procedure is already developed. It's clearly stated how it will happen, but what we have to understand that the material rights or substantive rights is done by a notary and only one time. So notaries have to be convinced that it was not done previously. But having access to our register, they would be able to check it and take a decision, and this decision will be adhered to the register for this person. It will be concretely said who is done and how done. So, and then will be clearly stated that the status has changed. Thank you, Mr. Dobrosedos. Oh, yeah.
Opening of new category by the Register of Damage as for the relatives of the missing persons. And of course, my next question will be to our panelist, Ms. Katarina Pisotska. She is a legal advisor at the Register of Damage for Ukraine. Dear Katarina, could you elaborate a little bit about this category, who is eligible to submit his or her applications, what are the requests, requirements, especially in the context of evidence? Also, what are potential developments of the situation? Maybe with the opening of new categories, something will be changed. And also, we all know that the Register of Damage for Ukraine is respecting and implementing human-centric approach. So maybe there will be some changes related to the evidence base. And of course, what are potential results of the submission of such applications for the relatives of missing persons?
Thank you, Katerina. And actually, this question is a great segue from what Mr. Dobroserdov has just mentioned about international cooperation. Indeed, it was mentioned already for several times by the speakers during the opening remarks that in early March of this year, the Register of Damage launched one of its, actually the third category that we launched for submission of claims. In particular, that's the category A2.2 for disappearance of immediate family member. And actually, this launch became also possible due to our fruitful cooperation with the Office of the Commissioner in Ukraine, and we're once again immensely grateful for that. So before addressing the question and going to the nitty-gritty of the category, I would like to remind about the role and the mandate of the register. Just, I think it would make it also clear how the register works, how it operates, and what are actually the consequences and the results of submitting and actually processing, reviewing the claims by the register. So the register was created in May of 2023. Once again, it was mentioned today during the opening remarks, and actually it's quite an important and significant historical event. If we look back at the history of creation and establishment of similar institutions, we see that usually they were established after the ceasefire or the end of the armed conflict. So it's quite a historical event for us to work already on recording of claims of damages here now while the war is ongoing. The register functions under the auspices of Council of Europe in accordance with the international treaty, the enlarged partial agreement, which is open for signing and which is also highly encouraged by other states. And what is important in the role of the register is that the register serves as a record in documentary form of all evidence, information, and claims related to damage, loss, injury that were caused on 24th of February of 2022 or after this date in the territory of Ukraine in the result of international wrongful act of the Russian Federation. It means that the register, as of now, it doesn't have any kind of adjudicative functions. So the submitted claims are reviewed by the register, and accordingly, the decision is made of whether to record the claim or not. And as it was once again mentioned, and I would like to reinforce this statement, adjudicative functions will belong to the future compensation mechanisms that will consist of the Claims Commission and Compensation Fund. And right away, I would also like to address a question that we at the register received quite often is, what about the damage and the events that were happening before 2022? Well, here, I would like once again mention that we as an international organization, we are functioning in accordance of our set mandate. And what is more important is that the register is the result of international efforts. So based on our cooperation with the government of Ukraine and seeing and hearing what Ukraine as a state is doing for those victims of this war, we see that our government is making all possible to make sure that those events and those damages and losses that were happening before 2022, they're also subject of future compensation. So having said that, I would like to go and address the question about the claim category that we launched in early March of this year, A2.2, that's the code name that we use for all of our categories. So this claim category is open for submission of claims for mental pain and anguish that families are suffering when they're going through this unknown, when a person disappears. What is important that in the register we undertook the approach of a quite broad definition who is actually an immediate family member that is aligned with the common international practice, also domestic laws. The term immediate family member covers parents, step-parents, children, step-children, also civil partners. But what is more important, the category is also open for submission of claims by other relatives. If such a person, a claimant, can submit evidence to actually prove that there were close ties with a missing person or some elements of dependence. So quite a broad range of who can be claimants in this category. What is important is that claims in this category, they can be submitted for both civilian missing and missing military servicemen. And the part that is quite beneficial here, and once again, I will refer to the Office of the Commissioner, as of now, claims can be submitted only in case if a claimant, if a person that is missing, and information about this person contains in the Unified Registry on person missing under special circumstances. So once again, we rely heavily on the evidence that is being actually now recorded in Ukraine by the Office of the Commissioner on persons missing under special circumstances. And just to quickly conclude, I would like to state that the work of the register, indeed, it's a core principle of our work that we are a victim-centered approach. And the work we do at the register, it's not just we're not just paving the pathway to reparations and future compensation for the victims, but I believe that for this specific category, that sensitive category that was launched in March of this year, we're also paving the pathway to acknowledge and recognize the suffering of those family members, which actually perfectly aligns with what Grazina was mentioning at the beginning, that we're ensuring that the rights and also voices of those family members that suffered of those disappearances, they are actually acknowledged and thus properly compensated in the future. Thank you.
Thank you, Ms. Pesotska. And of course, I do agree that we now all are passing historical moment, and the activities of the Register of Damage for Ukraine, this is something unique without any precedent in the history. However, for me, it's something about responsibility and obligations, of course, because this category is related to anguish, to mental pain, and we should not create false expectations for relatives. And here we should balance between, just to document, to register, to receive all these submissions, but also to have some ways and some vision how we will compensate all these damages. And of course, reparation is not only about compensation. And I'm sure that our next speaker, Dr. Yasminka Jumhur, will tell about this more. She is Ombudsperson for Human Rights of Bosnia and Herzegovina, member of the United Nations Commission of Inquiry on Ukraine. Actually, I met for the first time Dr. Jumhur during her visit and the visit of the United Nations Squad to Kyiv in 2022. So it's my pleasure to have you among our distinguished panelists. I would like to formulate my question as, could you reflect a little bit on the national obligations in the sphere of missing persons, and also how the national bodies should take into account international standards in this sphere. And as I know, the experience of Bosnia and Herzegovina is also quite unique. So maybe you can tell a little a bit about this legislation, institution, procedures framework adopted by this country, of course, in the context of some lessons to be learned by Ukraine.
Thank you. So many questions, short period. I don't know how to answer.
And you have only 5 minutes.
Thank you. First, I would like to thank ICMP and co-organizers to invite me and to be here. And also, I'm former member of Commission on Inquiry on Ukraine. I served first year of mandate, and that experience really it's very, very important for me because I was able to compare that what happened in my country, in Bosnia and Herzegovina, and what happened in Ukraine. I am also former member of UN Working Group for Enforcing Voluntary Disappearances. I was first woman in that body after 30 years since working group was established. I must say on beginning that what I heard this morning and yesterday during our preparatory meeting, comparing that what I saw in 2022 in Ukraine, there is big developments. I remember our mission in December in 2022 when was starting a discussion on establishment register of damage. How was big focus of authorities in Ukraine to establish register of damage, of material damage. And we pushed as a commission to establish damage towards human resources, to human beings, not only missing persons, but globally. I'm saying that because this morning has been mentioned several times intersectionality. And it is very important to take as principle when we are speaking on a registry to take in consideration that one human being in any country can be suffer from different reasons, can be member of a missing person, can be a victim of sexual violence, can be child, can be person with disability by natural, and also IDP. And all those elements must be taken in consideration when we are trying to find solution of that person for future, not only for today. And that's what is my concern, that a whole reparation as package is looking only from perspective of compensation. Compensation is one of element of reparation. And if we are focusing only on that, victims will not be satisfied. Based on perspective of Bosnia and Herzegovina, thanking really ICMP on their efforts, there has been developed a very, very broader understanding of importance to establish comprehensive approach to reparation. And second, it is very important to have permanent process of consultations with victims. But that consultations cannot be on ad hoc base, that it must be systematically and must be in law. There was established advisory committee, advisory board of victims of missing persons, and they are participating in all process of decision making. Without having their opinion, there wasn't possible to create any step forward because they are there. And they also have very important role in process of accountability, particularly in court processes. Many of you were able to see them in front of Hague Tribunal because they increase awareness on importance to bring justice. Third element is reparation, and when we are speaking on that 3R, first R is recognition. When you speak for any victim, not only a victim of a missing person, but other types of suffering, they are always asking, we need to be recognized in the law, we need to be recognized in practice. And it is not accidentally that we're starting this panel with definition of missing persons that must be looking in broader understanding. And if you're starting from that, it is also relevant for other victims. After that, victims must be recognized. It does not mean that recognition means that they will enjoy a whole package of reparations. Depends of level of suffering and so on. And recognition, after that, it's very important to see rights, and we are coming in issue which rights they need. You need to listen to victims. Example, if we have a child who is member of missing person, what is with the education of that child? What is with access to social benefits? Do they need to have some priority comparing with others which have not suffered any and which have not any damage? And so on. After that, access to health, access to enjoyment of social inclusion, of it is a set of rights which they must be ensured. And on the end, it coming third reparations. And under reparations, we are coming from the process to try, what is reparation? It is process to return a victim in a level of living before it happened violation. It is not possible always. Example, if we are speaking on if a house is destroyed, maybe it will not be possible to return person in previous living place. And some of victims, for example, missing persons, at the same time they are victims of rape. And one woman told me, I'm not able to return in that house because she was entitled to return in that previous living place. But she said, I suffered, I was raped in that house, and I'm not able, and she didn't tell her husband that she was raped, and after that, when the whole story was discovered, she lost husband, she lost family life, and so on. Take in consideration that intersectionality of violation and be sensitive for needs of victims. And I would like to return on that question of LIP legislation. European Court and international standards always asking that everything what the government takes must be based on the law. You can't only impose measure, you can't only establish register if you don't prescribe clearly in the law, and also bylaws are very relevant to prescribe that procedure. We are coming in that third, LIP legislation. Institutions, I'm so glad that was mentioned education of staff in institutions which should implement that. It is permanent process to educate institutions how to implement new legislation and also to ensure clear procedures related to implementation of new legislation. It is very, very serious challenge because we have big crisis of international order. When we have a big crisis of international order, as my friend Krezina mentioned, problem in communication with states related to individual cases. It is ignorance of international order by some states. In such situation, all of us have serious responsibility to find solutions, new formulas, how to solve, how to deal with problems. Is it regional cooperation? Is it bilateral, strengthening bilateral communication, and to involvement all of us? I will stop here, but definitely coordination, it's important, coordination of authorities, and to finish with the P5, prosecution of responsibility, and for them is also victims very important. If you don't have registry of victims, including missing persons, you will come in situation that tomorrow you will not, you will have problem to find witnesses in court procedure. It happened to Bosnia and Herzegovina. Protection of victims, participation of victims in all decision-making processes, and prevention of further violation, what means work with civil society. I will stop here. I think I put that in 5 minutes.
Yes. I have my own mic. Thank you. Thank you very much, Dr. Jumhur. And you also, as our speakers today, highlighted many times that we have this need to take into account the unique situation and the unique needs of each of families of missing persons. That is why I would like to introduce my Ukrainian colleague, Ms. Tetiana Katrichenko. She is Executive Director at the Media Initiative for Human Rights and a dedicated human rights advocate and activist, known for her work on issues related to missing persons in Ukraine. Dear Tetiana, continuing this issue related to the fate of missing persons and also of the needs of their families, can you tell us, please, what difficulties are faced mostly by these family members in establishing contacts with Ukrainian but also with Russian Federation authorities? This is the first part of my question, but the second part, which I find really actual regarding all these technical consultations in Arabia Saudi and also the point 4 of peace formula related to the return of civilian detainees in particular. So, do you believe that as for today we are able to establish some mechanism for repatriation of the missing persons from Russia to Ukraine? And should we prioritize this task during this peaceful negotiation without any concessions in this sphere?
Thank you, Katerina, and I have only 5 minutes.
Yes. Of course, between 5 and 6 minutes, but I'm sure you will succeed.
Дякую, колеги, за запрошення.
Thank you, dear colleagues, for this invitation. I'm going to speak in Ukrainian. There are a lot of questions, and I'm going to be short in my answers. We, as a NGO, one of the biggest NGO in Ukraine, every day talk with families of missing persons, with POWs and civilians detained by Russia. And we feel all their pain. But I would like to start from something else. I am from Kiev, and the capital of my country, the Russian Federation, wanted to get into in 3 days. They were not able to do it in 3 days. Our army stopped them a couple kilometers before Kiev, the Russian army. The part of the Kiev region was occupied. The occupation lasted for 1 month, 1 week, and 1 day. During this period of time on the territory of Kiev region, occupied territories, thousands, hundreds of thousands civilians were killed. But based on the last statistics that I see in the Ministry of Internal Affairs, the missing persons from that time, it's like more than 4,000 citizens. And for us, for Kiev region, that's a huge amount of people. For example, missing person is my colleague, journalist of the big information agency Metro Heluk. During the occupation, he was at his house. He was working as a professional journalist, and he was detained by the Russian military personnel. Then he was taken to the territory of the Russian Federation through the territory of Belarus. Already over 3 years, Dmitro is in Russian Federation detention. We know that from the people, POWs that were returned, but Russian Federation officially did not confirm that Dmitro is there. They did not confirm where he is, where this journalist is detained and kept. And in the list on the register of missing person, my colleague is there as well. Also, I have another colleague, Katerina. We work together. She and her boyfriend were detained while Chernihiv region was occupied. Katerina was let go, but Mikhail Buzin not. He disappeared. He is a missing person. And no one knows where he is. We're looking for him on the territory of Russian Federation, but we don't know about whereabouts of this person. So I read a lot now about the experience of Bosnia and Herzegovina, and I understand that this conflict on one side is similar to the Ukrainians, but on the other it's very distinct. In Ukraine, from the first days of the full-scale invasion and first days of the armed aggression of Russian Federation against Ukraine in 2014, we are trying to document a lot of statements and facts that are happening on Ukrainian territories. In parallel with our government, we are trying to document the infringement and crimes that were committed on the Ukrainian territory. And these initiatives about documentation of the crimes committed are not only done by the CSO and law enforcement or agency, but also families themselves. Yeah, they are creating community. Institutionally, they are weak, they are emotional, but they have a huge desire to work. And what's most important, they are trying to find an answer to the question that the government is not able to give them. And especially the law enforcement agencies are not able to give them the answers. We can say a lot that the specificity of the Ukrainian conflict and Ukrainian war, and today we have heard that, is that the Russian Federation. So when we talk about the missing persons, we don't talk only about people that were killed on the battlefield or they were under shelling in Mariupol. We talk here about people as well that Russian Federation knowingly detains and hides on their territories. When we talk about the civilians, our organization has a list around 2,000 civilians detained by Russia that we were able to identify, and they are on the occupied territories or on the Russian Federation's territory itself. So, no letters, no packages, no telephone calls could reach these people. Russia cuts any possible communication with next of kin, with representatives of government in Ukraine. Yes, there are confirmation by the International Red Cross, but it's also done by way of lists and they meet people. So we understand that when an International Red Cross confirms that the civilian is detained, it doesn't mean that this person is on the territory of Russian Federation or he will be alive by the time of exchange. Because last year on the territory of Ukraine, the Russian Federation gives bodies of murdered, of tortured Ukrainian civilians that before were confirmed by the International Red Cross as detained. So, what families want? They want to receive information. The second request, it's a communication with the state authorities, that communications with them, it's clear. And thirdly, feel that government and state cares. Fourth, that is return home person, missing person, that was detained. Of course, we do understand that some would return alive from the Russian prison, but someone's bodies or what is remaining from the body will be returned later. But this fact that you know what's going on is very important. And it's important for the families that we're talking with about this. They want to cooperate with government, with international organization, with CSO, etc. And today we talked about the point number 4 of peace formula. Norway and Canada work with Ukraine on this. We thank you very much for this. we have tasks for these countries, Canada, Norway, and other countries. We have a task when we talk about the number 4 of the peace formula, when we talk about the exchange and return of all POW or children or civilians and all remains of missing persons or missing persons themselves. Even though we talk less, we would like to have return of these people. When we talk about the civilians detained by Russia, we would like to say there is not established mechanism of search and return of these people. Geneva Convention states about the mechanism of return of POW. We know how to exchange bodies of deceased, but we don't know how to find civilians that are also included in the register of missing persons. When we talk about exchange and return, we need to have a plan how to return civilians. Our organization offered some proposals for such kind of plan. We would like to identify these people, to split them into short, small groups, and then we would like to ask our partners to try to communicate through third countries with the Russian Federation about return of this person, because Metrocheluk that I mentioned in the beginning has no chance to be returned, and his parents that are over 70 years old are afraid that won't see him anymore alive. Talking about the register of damages, as I mentioned before, compensations and reparations are not a very urgent problem right now for Ukraine. It is very important. It's important in supporting Ukraine. But families want to firstly know the truth and find their next of kin. We see that the opening of new categories and existence of such a register is very important, because in Ukraine we talk that on the territory of our country we have documented over 150,000 war crimes. None of the legal system, none of the investigative bodies are able to investigate this kind amount of crimes. And I'm not sure that all or majority of these crimes will go to the court hearings themselves.
However, the victims shall submit notifications on such crimes, and this must be submitted to this register. This register will help us to document all crimes being committed in Ukraine. This will be a book of memory, and this will be also a stock of all the damage inflicted upon Ukraine during this armed conflict. Now we speak with the families, and even if we have no news, we still tell them it is important that you go to the register and submit a claim.
That to understand that we are really grateful for the solidarity and constant support of our foreign partners as for the point 4 of the peace formula. But in the context of the repatriation of our prisoners of war, civilian detainees, including Ukrainian deported and forcibly transferred children, we need concrete steps, because every day under Russian control, this is a day of mental suffering, torture, ill treatment, not only for these persons who are detained, but also for their family members. And that is why, of course, no concessions and no questions about not to prioritize the repatriation of people in the context of gaining fair and lasting peace for Ukraine is just unacceptable. So we should continue these efforts. And our panel, we will continue with also my Ukrainian colleague, Alona Lunyova. She is the advocacy director at the Zmina Human Rights Center and a prominent Ukrainian human rights advocate. Dear Alona, what steps have already been taken in Ukraine today to provide proper support to missing persons and their relatives? Especially, also maybe there are some peculiarities in the context of persons who went missing before the full-scale invasion.
Thank you for your question, Katerina, and I will continue in Ukrainian, so please use your headphones.
Indeed, would like to continue about the significance of international support. It is important today, and it was important in 2022. I am from Crimea, and I know about the type of support that was given to Ukraine since 2022. Well, the search for missing persons, that's a very pertinent question to Ukraine that became very poignant question starting with 2014, February 2014. Then we had first cases of enforced disappearances and missing persons. And now we have thousands and thousands of people missing. And the law on the legal status of persons missing in special circumstances was first drafted in 2016 when part of Ukraine was already under occupation. So we already knew then that it's important to develop a system for search and identification. At that time, in the occupied territories, people were missing, and obviously the Ukrainian authorities were not capable of taking certain actions in the occupied territories. So it makes Ukraine different from other countries, as in other countries the legislation on the missing persons was passed and adopted decades after the end of an armed conflict. But our legislation was actually passed in 2018, and it is very much victim-oriented. We are providing for some safeguards for the families and also providing for such mechanisms. So this is our special context, because our country, our government is developing a system. And for instance, the Commissioner for missing persons in special circumstances is a very good example of this approach of the government. And the law has given us three important elements within that system of search. That is the presence of institutions, we have the register, and we have support measures. So now we have developed a certain system of giving support to the families. Well, it's not a comprehensive system yet, but already some elements are already in place. Now, talking about institutions, we need to say that the Commissioner for Missing Persons in Special Circumstances operates under the Ministry of the Interior. It's a very important authority that is responsible for coordination. And when we're talking about the day-to-day work, after 2022, today we have heard that more than 63,000 people are missing, but I've already seen a number of 70,000 people missing. And in the register, we have more than 60,000 people registered. So in 2017, it was just 1,000. Now it's 60,000. So obviously, the task of the Commissioner for Missing Persons and of his secretariat is to coordinate the activities with other authorities and organizations mentioned by Tatiana. They cooperate with the organizations of families, for instance, and they're helping them to establish the whereabouts of their relatives. So this system of coordination, information is necessary because that is in the interest of their families, and there is demand for this type of services, and this is something that needs to be worked on and improved. Now, the second element is the register of missing persons. Now, the register is super important. It is important to run a register of the missing persons, especially now when we're talking about the negotiations. Whatever you might think about negotiations in their current form, but we know that so far, as for negotiations, they're talking about the return of the prisoners of war. And there are no demands voiced yet to give information by the Russian Federation on the whereabouts of our missing persons, but this must be a part of the negotiations. That is why we need this register. This register is the most comprehensive database about the people whose whereabouts are not known to us. We know that they were taken out, that they disappeared. We know about some people from the prisoners of war who have been returned. At least we don't have any problems with the definitions, whether this is, for instance, a civilian person who has been unlawfully detained is still registered in this register. Of course, there may be some confusion with the different categories of people in that register, but in this register we have the largest number of categories of the victims, of people whose whereabouts are not known to us. So this register needs to be supported. This register perhaps will be a part of the system of the registration of all damages. But let us be honest. This system of registration was approved by the law. The law was passed in November 2024, but that system, which is a huge register of intangible property damages, that register was meant to be funded by the USAID. As you see, it's most probably unlikely these days. So we need to think how to take stock of the intangible damage caused by the war. And from what I know, $15 million, that is the price tag for that system. But we need that system. It needs to be operational. Now, we also need to talk about the families and their needs. Tatiana has already spoken about the families' needs. We understand that there are civil society organizations. They have some tools and they're capable of assessing those needs. But communication is not the first need that is being articulated. But still, thinking about their needs that they may have and the needs that are not being emphasized that much these days is that the people do not know what and how could be done. We hear from people that they would like to have a tool for memorialization, a place to go to come and reflect upon those who went missing. But it should not be a cemetery. It must be in a different shape and form. And in Ukraine, we don't yet have a discussion proposal on different forms of memorialization. And perhaps memorialization is still a need, but sometimes people are shy of speaking about memorialization because when they think that if this is going to be an act of memorialization, it would be as if to admit that they're already dead. But perhaps memorialization is the space or the topic we could think about. So that is the demand the families actually have, so that these families have a possibility to choose a form of memorialization they deem fit. Because we have quite a large number of the missing since 2014, and we do not know whether we will be capable of establishing their whereabouts in the future, but at least some form of memorialization is needed, because these facts of disappearances need to be also part of memorialization. Thank you.
Next panelist, I would like to tell you that after Ms. Franziska Eckelmans, we will have a short coffee break. So please return after these 15 minutes, because then we will have a questions and answer session, which I think is the most interesting part, actually, of our discussion. So, last but not least, yes, now, Ms. Franziska Eckelmans, you are planning to speak now. So Ms. Franziska Eckelmans is a legal advisor, deputy to executive director of the ICC Trust Fund for Victims. As we know, for example, Ukrainian deported and forcibly transferred children are also in the register of missing persons at the national level, at least. And as we all know, that the ICC issued already 2 arrest warrants related to the case of unlawful deportation and forcible transfer of Ukrainian children. In the context of the activities of the ICC Trust Fund for Victims, I have several questions to you, of course, just for the answer of 5 to 6 minutes. And the first part of my question is, does the fund have programs relevant to Ukraine's experience in supporting missing persons or their family members? And is there potential for such a program to be developed in the context of victims in Ukraine? What we should do in order to have this program in future?
Thank you so much, and thank you for having me here as a representative of the Trust Fund for Victims, especially to ICMP. Very grateful also to be together with this very distinguished panel, and so many, I think, ideas have been expressed already, and facts of what is going on in Ukraine in order to actually find the missing people and the missing person. So I think that is what we have heard. And what I want to add here is really, and underline, is the experience of the Trust Fund from bringing reparative justice to the victims of those who have been convicted by the ICC. And before I start really to address your questions, a short introduction to the Trust Fund for Victims, I think, is necessary for many of you, although also there are very many, I see, representing embassies who have a very strong link, of course, with the court and with the Trust Fund for Victims. So the Trust Fund for Victims has a board of directors and therefore is kind of separate from the ICC. And that board of directors is in charge of the funding that comes to the Trust Fund for Victims and directly goes into the programs for the benefit of victims. The Secretariat has 30 people, part of them in the field, the other part here in The Hague. And the Secretariat is funded by the usual budget of the court. We make 4% of that budget of the court. So everything the trust fund collects directly goes into the programs for the benefit of victims. And our main task of this board of directors and of the Trust Fund for Victims is to actually develop programs for the victims of those who have been convicted by the ICC. To date, there have been 6 convictions. We have finished 1 reparation program. We are processing 3 more at the moment, so implementing them, and we are in the process of designing new programs. And how are we doing that? In the very first place, on the basis of the reparation principles developed by the court in their jurisprudence over time. Now, since the Ongwen judgment in the Uganda situation, these reparation principles have been rather settled. We expect now a next appeals chamber decision next week, but they have been settled, and you have heard also the principles expressed by Bernard Duhem, but also here, prompt, adequate, proportional reparations, transparent reparations, non-discrimination principles, gender sensitivity, victim-centeredness, do no harm principles. All of that is set out in the principles and is guiding the implementation by the Trust Fund for Victims. But our mandate goes further than that. We can also run programs for the benefit of victims in situation countries of the ICC, where the court has become active. We have heard there are arrest warrants by the court in the Ukraine situation, and indeed we already also got some funding to start processes for now also a program in Ukraine. And we have been doing that in
І ми це робимо в Уганді з 2800 році.
Over the past many years, and we have provided in particular rehabilitation measures. In Uganda to about 90,000 victims, in the DRC to about 60,000 victims, individuals, and beyond that also other measures. So in the sense of making sure there is an understanding of the situation of the victims of the crimes that happened. And in Côte d'Ivoire, where we had acquittals by the ICC, for example, we have been running also symbolic and memorialization measures. So I think it's important as a background. So yes, so we could be active also in the Ukraine as such, and we have a lot of experience that I want to bring in now. So I think when we talk about reparations, there is, of course, as a very essential principle, first, the compensation element. But beyond compensation, and we have heard that from so many other contributors today, there are very important other additional elements. And they serve several purposes. They serve recognition, they serve psychological healing, and they serve in the very first place also the next generation. So reparation is a process. It is not just one moment. It's very often a process that should lead, indeed, as Bernard Duhem had said in the very beginning, to prevent the recurrence of the crimes. But how do you do that if you do not address the psychological situation of the victims and those of their children and grandchildren. You need to address that the harm suffered in and of itself, and you need to recognize it together with the community. That is so very essential, I think, for reparations. So very concretely now, I have 4 questions. For whom the reparations? It's for the direct and indirect victims, whether they are now direct victims, as suggested by you, as a family member, but it's for the direct and indirect victims. So it doesn't matter in that sense whether the family members are, they are the ones who are suffering. They are the ones who need to be addressed in the case of the missing persons. And there need to be presumptions of harm suffered. If you ask a family member to say, oh, now I need to prove that I'm suffering psychologically, that's very hard. Presumptions are very important, established also by the ICC to make people eligible, to find people valuable for reparations. How reparations? It's very important that the states are involved. This is what victims are always asking. State or states. We are the Trust Fund for Victims, but for the victims in the DRC, in the Katanga case, who participated in the proceedings, it's the recognition of the entire international community through the Trust Fund and the ICC that really matters to them. It makes a big difference. In Ukraine, I think it is such a valuable and important point that Ukraine authorities are on top of reparations and are involved and want to be involved, that every reparation initiative must go as part and go along with and as part of a Ukrainian initiative. We heard that there should be laws, ideally, etc. That also ensures non-discrimination. That ensures everyone is involved. Very important. How? Other aspect, victim-centeredness. Victim-centeredness, and beyond that, strengthening the agency of victims. So for the ICC, victims participate, of course, in the proceedings. But once there is a reparation order by the court, we go, as a trust fund, we go and consult with the victims about the drafting of the implementation plans. And then we keep consulting. That is what we have learned. This is our lesson learned. We have applied that in the Al-Mahdi situation in Timbuktu, where we have communities, committees throughout the Timbuktu community, consisting of victims, but also of the entire community, who contribute and give opinions on every step in the process. They need to own the reparation process. It's so very important. And in the Ongwen case that we are just in the process of now developing, we have already consulted with 5% of the victim population to make sure they are included, and we keep consulting. So our colleagues last week went there, for example, and consulted about a participatory mechanism. How do we now involve the victims and the communities in the reparation process? And members of the community said, when we saw the reparations order, we thought that might really raise so many issues and potential conflicts. But now, knowing how you want to start doing this and being involved, hearing from you how you want to do it, we think this will actually be successful. So this is a huge message to hear. And I think this is so important as well if you go into the Ukraine context. You need to involve the communities and the victims and hear them in the process. Every step of it needs to be designed of it. And that then leads to also measures that are feasible. There is not an endless amount of money. It is not always possible to fully restore somebody to the situation before in a conflict situation. But if the victims are involved in the process and they know the limitations of it and they have ownership of it, there is nevertheless a very strong healing component. And we have seen that in the Katanga case where we have measured it, and the victims, even before receiving psychological support, their psychological situation and state of mind was much better than that of the comparable group of the comparable population. So to be involved, to be recognized, is important in order to actually take a step in the healing process. And that, again, has the positive effects for the next generation. So this has already answered the what. What is very much a matter of design and implementation together with the community, and also of availability of psychologists, of availability of the personnel that actually needs to be there to provide the services required for healing. So that both goes together. It's not only always a question of money, it's also a question of getting the right and sufficient experts with us. And then symbolic and commemoration measures, as were just mentioned, I think that cannot be underestimated, how important it is to find the right measures and also to take the time. You said, oh, they're not yet there, but the conflict is ongoing. There is time necessary for everyone to get involved and to think about it and also to feel what has actually happened to me. Yeah, I think the rationalization also takes some time. I think that's important as well, to my mind. So I think I want to conclude here and look forward to the discussion we will have after the break, and I hope you stay here to also follow the discussion.
Thank you, dear Francesca, also for respecting our strict time limits. I would like just confirm that really the ICC Trust Fund for Victims is always consulting non-governmental organizations in Ukraine, including my organization, Regional Center for Human Rights, as for possible shaping of some reparation programs, especially in the context of Ukrainian deported and forcibly transferred children. So this is already our reality and everyday cooperation. So thank you so much for this. And as it was promised, now we will have a really short coffee break. Please return to the audience.
Да, тобто це виходить одне те саме.
And in what time tomorrow you will be at home?
At 11 p.m. No. And I'm really preoccupied how to go to my home after the train because even taxis are not really willing to pick up me and to transfer me. Because it is very close to this police time, so. This is experience, you know. А я скажу, що ви будете мені допомагати. Я буду так пальчиком показувати. Mm-hmm. Maybe yes. So, distinguished audience, Your Excellencies, we will continue our panel discussion, and as it was promised, we will open our session of questions and answers. But before, I would like to ask our panelists, maybe you would like to add something to our previous discussion, or just to address or to comment something or answer some questions raised by other panelists. So feel free. But I would like to ask you to keep your comments like 2-3 minutes.
Thank you for possibility to make some comments. And I again switch in Ukrainian.
I think that this is going to be a general commentary, but I need to say this. Ukraine is developing its system for the search of the missing persons and other categories of victims since 2014. We had a government that developed a support system. So the support system, more or less effective, it is actually in place. We have a system, but we need to take into consideration the national experience we already have. This is important. We need to recognize that Ukraine has its experience. It's not like back in 2014 or 2015 when we were just beginning and we were open to study the experience of others. Now we have had 11 years of our own war. We have our own experience. So many can now learn from Ukraine. That is the experience of Ukrainian state authorities, and we are very much flexible. In 2014, the war began, and the first law was passed in April 2014, merely a month and a half, less than a month and a half since the beginning of occupation. In 2014, October, we had the first law on the IDPs and the national system for the registration of IDPs. In 2018, the law on the missing persons, and later on other laws on unlawfully detained and so on and so forth. So we have many laws and we have experience. It's interesting to see what could be used in Ukraine on the basis of the international experience. But now it's a sort of a balanced situation where many different actors may benefit from this experience. We also are thinking about the instruments that the Russian Federation is using so as to control the civilian population in the occupied territories. And one of the recommendations of the special report was the establishment of the NATO Center of Excellence in the territory of Ukraine, or for Ukraine, that will look into the experience of the occupied territories. Learning about the experiences of the occupied territories is very important. We need to see what the Russian Federation is actually doing in the occupied territories. Also, we need to see and understand how the Russians are treating our civilians and the military. So do study our Ukrainian experience. It may be of great benefit for many partner countries. Many thanks.
Comments. I think it's really valuable to hear. Dr. Baranovska, I see you would like also to intervene to our discussion.
Yes, very shortly, and inspired also by what has been said before, but also by what you said. So Ukraine is also, from the perspective of the working group, a very rare example of authorities that are genuine partners. So where you would really see that they are also responding to the requests of families. So you see changes adapting to what's happening. So that is indeed exemplary. What I do think, especially since we're on an event on reparation, keep in mind, though, is that reparation is a long-term process. So it's not something that can be addressed within 5 years. It's having a missing person in your family goes down for generations. And there are countries that are dealing currently with grandkids of those that have disappeared and are trying to provide help for them. And we do know that that's going to be the situation in Ukraine. Some people will come back and they will need to require psychological help, others will not. And the communities will have to deal with that, both with those that come back and those for whom the place misses. And where I think that still a lot of experience from other regions can be brought into Ukraine is this notion and this thinking that this is really a long game. So this is really something that Ukraine can take on board and think about when developing policies to acknowledge that this is a phenomenon that Ukraine will have to face, not only today, not only in the search, but really in many years to come.
Thank you. Dr. Yasminka Jumhur.
I will continue in this way. As I said on the beginning of my presentation, there is really serious, significant improvements on side of Ukrainian authorities. When we spoke on victims in 2022, an obligation to establish the register, they were very quiet. But today, there is no more that position. I only see, not only today on this event, on many, many other events, there is always a go to do that. And it is very important when you have a serious partner ready to do things. In context of that, it is also very important that Ukraine is on way to develop own new way, because when we developed that in Bosnia and Herzegovina, it was first country in world which had a law on missing persons and so on. But now Ukrainians are able to develop own way because of circumstances. And in that context, I would like to say that what my colleague Razina said on beginning related to definition of missing persons and everything what is defined in international standards, it is minimum. Don't forget, it is minimum. Ukrainians must listen their victims and follow their needs because they can develop that more than that is prescribed in international standards. And the third, what I would like to say related to reparations, memorialization is very important. Maybe it is not priority today, but it must be prescribed in the law. And must be think on that and to consult with victims in which way they want to define that. When we spoke with authorities of Ukraine in 2022, the prosecutor office at that time had the highest understanding of needs of victims because they recognize that victims are tool in their hands for truth and for justice, because victims are witnesses. And don't forget that element, what is very relevant if we are speaking on true justice and finally on reparations.
Thank you. So these 10 minutes have just shown to us that our speakers are really well prepared to address all your questions and to elaborate more and more on this very complicated issue. So let's create a dynamic and insightful discussion together. Please raise your hand and our team will assist you. You will be the next.
Hi, I wanted to ask whether any of the panelists had a response to the idea of a certificate of absence that Catherine suggested right at the top, unsuccessfully in Sri Lanka, maybe more successfully in Bosnia. Maybe our Bosnian colleague can speak to that a little, and whether that's something that's on the cards.
And can you please introduce yourself?
I apologize.
It's okay.
Janet Anderson, journalist.
Thank you. So, who would like to answer? Take more questions. Okay, so this woman from the first row.
Hi, my name is...
But if I may, I would like to give an answer.
Назбираємо питаннячка, а потім ви відповісте.
And then we'll begin. You'll be the first one to answer.
My name is Rosalind. I'm head of legal at ICMP. But I just wanted to comment on the first speaker's. You were talking about definitions, and of course there isn't a strict definition of missing person, but ICMP is working on a working definition of this. We say that missing person means a person who is missing due to involuntary reasons and who has not yet been located. And we think it's important that we take a wider approach because, as you say, in forcibly disappeared persons, it's a very narrow definition, but every person who's been forcibly disappeared is a missing person, but not every missing person has been forcibly disappeared. So we just wanted to, I wanted to make that point. Thank you for everyone's contributions today.
Thank you. So, Mr. Dobrosierdo, I suppose you can answer this first question.
Yes, we may have different approaches to the certificate of absence, the certificate you're asking about. But let's have a look. How about the copy from our register, from the single register of the missing persons under special circumstances? As they say, there are many beautiful laws, but sometimes laws are very difficult to implement, to enforce. But nonetheless, as for now, we have a document, it's an official document, and it already opens up certain avenues for the families of the missing. For instance, they may ask for the financial benefits to be paid out with, in the case of the loss of a breadwinner. Also, some cash aid is paid out to the families of the missing. We yet again have introduced some changes into our legislation, and it's working. For instance, the relatives of the missing persons have the right for the deferral from the service in the armed forces in the case of mobilization. So if one brother is a missing person, and if another brother in the family is taken to the army, or the father is taken into the army, this may be a major loss for the family, so they're deferred from the military service. Also, they are receiving some other benefits, such as stability of employment or position. So we understand that we need to take into consideration the regular life of these people, but we also need to take into consideration the damage inflicted upon their property. So in practice, we already have developed some mechanisms. For instance, if there is a woman and she says that she has two nephews and both nephews went to the army, and one is officially a POW and the other one is a missing one, and those two nephews had built two big buildings before serving in the army, but formally she cannot pay for the utilities in those two buildings, but the owners were her nephews. So it's important to provide for the safeguarding powers to take care of these two pieces of property. So once she has the copy of the document from our register, she may have many more legal avenues for further work. That opens up new avenues to go to court and apply at court for other decisions. So this document actually works.
Why we need to have that certificate? It is question. Reason why relatives asking that certificate is really to enjoy other rights. And if authorities in Ukraine providing by other pieces of legislation access to those rights, there is no need to ask that certificate in this stage, because we still don't know fate on that person. And definitely solutions should be created under circumstances of state. If there is possible to create better solutions than we created in Bosnia and Herzegovina, it is good, but most important is to prevent that relatives must go to court to announce disappeared person as dead. It is very painful for them, and it is reason why created that solution. I also would like to remind on practice of a UN working group for enforced involuntary disappearances in case of Morocco. They accepted a state. They said, okay, we are taking all responsibility by international law, and we will accept that all disappeared persons are dead persons. They issued that certificate to relatives. They paid compensation, but those cases are still open within working group, because we took position that there is no truth about that what happened. Fate about disappeared persons have not been discovered, what means we are not able to close cases. And definitely, if we are speaking on of certificate in absence, it is if it is only tool to achieve other rights, it is better to find other solutions, and I supported this Ukrainian approach, but they must be faster in that to provide all needs of victims.
Dr. Jumhur has already mentioned the experience of the working group, so Dr. Baranoyska would like to add something also to this point.
Yeah, actually more on the law, on the international law. So the closest we would get to were, and actually I'm also a huge, I don't know whether also, but I'm a huge fan of the certificate of absence. I think they can give a lot of good things in society if implemented in the right way, as you also mentioned. The document that has the legal meaning for that would be the Convention on Enforced Disappearances that requires states to regulate the status of the disappeared person. So it does not prescribe either a declaration of absence but this is interpreted in a way that it's not sufficient to give a death certificate as interpreted for years already by many different bodies. But how this exactly can be seen is, of course, lived by a country, is, of course, very different. So another document can also make that possible. And the two elements that we would usually look into as a working group is, firstly, that a family is never required to get a certificate of a person that has died to get access to any services. So this would be really the number one. And then the number two, whether the wishes and the requests of the families are also taken under account. Because some families would actually prefer to have a death certificate, but other would prefer to have a certificate of absence, and other might prefer to have something else. So in that sense, we're back to looking at the country and the situation, being in dialogue with family associations, with victims, and finding solutions that really work in that country, and that, while not, again, not requiring to assume somebody has died, allow families to have access to inheritance, to family law, to all of that, in a way that complies with what they believe has happened to their loved ones.
Thank you. Thank you, Dr. Baranowska. Maybe we have some questions from our audience.
Carry on asking questions. Hello, sorry, it's me again. I was wondering, to follow up on the legal side, you were very careful, Dr. Baranowska, with using the definition of enforced disappearance from the convention and not the one that is in the International Criminal Court's Rome Statute. But Ukraine has signed up to the ICC, so on what, which definition are you going to use in the future, Ukraine? And what are the issues around that?
Thank you for your question.
Should I?
You can start.
Okay, I can start, but I would actually love to hear also the Ukrainian counterpart on that. So first, looking at, so we have in international law two definitions of enforced disappearances, one in human rights law and the other in international criminal law in the Rome Statute. They're not that different, right? To be in essence, they describe exactly the same circumstances, meaning the deprivation of liberty by authorities and then the concealment of the fate. There is a couple of differences between the two. So in the Rome Statute, the enforced disappearance can also be committed by a political organization. That means not only by a state. In the Ukrainian context, that would not really be relevant as such. The other big difference is that, according to the Rome Statute, the disappearance needs to be conducted for a prolonged time. How exactly this would be interpreted is a matter of discussion, but we do know of a number of cases, for example, of civilians that were abducted by Russian authorities, then kept forcibly disappeared for a number of weeks, and then reappeared in front of a court, right, of a quasi-court in the occupied territory. So under international human rights law, there would be no doubt that until reappearance, that person was forcibly disappeared. Under the Rome Statute, there would be questions whether that's a prolonged period of time and whether we could classify that as an enforced disappearance. And I'm even taking away now the complication of that only being considered in an attack against civilian population, just the definitional issues. So we do have two definitions, and the recommendation of all human rights bodies, and as far as I understand, that's what would also be where Ukraine is heading, is to rely the domestic legislation rather on the definition that's under human rights law, which allows to cover more enforced disappearances and is more precise with regard to the disappearances. I forgot the third rather prominent difference is also that, according to the definition in the Rome Statute, it needs to be done with the wish to keep, with the effect of keep the person away from the protection of the law. So why the protection of the law is also part of the human rights definition is not as prominent as in the Rome Statute. So there could also be an argument that somebody who committed an enforced disappearance would argue, well, the intention was not to keep the person from the protection of the law. So here, the many questions that would be caused by applying the definition on the Rome Statute would, from my perspective, really call for an application, especially in a context like that, where we do know that those shorter-term disappearances have happened, to apply the definition of international human rights law.
So maybe someone from Ukrainian side, Mr. Artur Dobroserdo.
Щодо конвенції
Talking about the convention about enforced disappearance, we know that Ukraine is using the legislation of 1992. In Geneva, our delegation has reported how all the bodies of this convention is ready and prepared by the agencies of Ukraine. We're talking about this, our national code of forced disappearance. Also, our legislation has a lot of regulations regarding this, the requirements involving enforced disappearance. When you talk about Ukraine, we talk more about issues of missing person. Talking about the enforced disappearance, we also talk about the disappearance where the law enforcement agencies are involved of the aggressor state. But talking about today's reality, our accents have been moved. We were heard, we were understood. So currently, we do have official accreditation that we do have these provisions in the national legislation, so we work based on that. But the most accent is now on the enforced disappearance on the occupied territory due to the full-scale invasion.
Comment. Стаття про насильство.
The state about the chapter on enforced disappearance, we talked about it also when we were talking about the legislation. Okay, we were concentrating on the government's actions. That's true, but 2022 changed a lot. But the enforced disappearance by the Russian Federation are qualified as a crime, not enforced disappearance based on the criminal legislation. That's why the practice a little bit differs, because the crimes that we consider as enforced disappearance, that's the crimes that can potentially be conducted by Ukrainian law enforcement agencies, but the reality is such. We qualified it as the crimes, war crime done by the Russian Federation. Maybe the Rome status legislation will do some consequences for our national legislation. After our ratification, we have not adopted criminal code yet. Now we expect the adoption of the complex adaptation regulation based on the adaptation to the Rome status. So we're going to see how the regulations of Rome status will be implemented in the criminal code of Ukraine, and also implementation of the provision of the
That this enforced disappearance in the context of the Russian aggression, they have a large-scale and systematic nature, and that is why they may be qualified as a crime against humanity. And we didn't have the provision on the persecution of the crimes against humanity before the ratification. And of course, we didn't have a national practice. So we should also think about how to train people, how to elaborate all methodology and guidelines, how to prosecute this type of the international crime, and so on and so forth. So we have a huge way to pass in order to guarantee justice for victims of enforced disappearance in Ukraine. Do we have other questions? Oh, it's very, very well.
Okay. No, I want to thank all of the panelists and ICMP and RD4U and everyone for an amazing discussion today. I didn't think so many people would turn out, but I think, it's not only important for Ukraine, but also us nerds who enjoy these types of discussions about claims. But just one quick observation, especially in light of what Janet is saying and what Ukraine might do, and this will be a question for Yasmina. ICMP has been very public in saying that the Convention on the Protection of All Persons from Enforced Disappearances doesn't go far enough. And in fact, states are responsible for finding missing persons and investigating their disappearances, but they should be responsible for all cases. And as Graziana said, enforced disappearances is a category within missing persons. But when you try to apply this, following large-scale disappearances, of which Ukraine has, and as Aliana said, Ukraine has amazing pieces of legislation, and the 2018 legislation on missing persons is very good. The problem is there is now a need to change the legal framework, as we have discussed with Mr. Dobroserdov, because the scale is so huge. And that's the issue here, is how do you then change legislation now to accommodate, and that is ongoing at the moment, to accommodate the scale and the need now for international cooperation with others to address this, because the scale exceeds Ukraine's ability to do this on its own. It's just impossible. So I think, looking at the legislative framework in that regard is very important, and the changes that would be needed to modify that. And also looking at cases of missing persons more broadly, which is what Bosnia-Herzegovina did, because you don't know what the circumstances were of the disappearance until you've conducted a thorough investigation. And families of the missing also need to access rights while those investigations are ongoing. So for a woman, for example, to declare members of her family dead, to be able to access inheritance rights or even custody of children can be complicated. So I think maybe, Yasmina, just maybe before we close, is perhaps to give a little bit more information about the law on missing persons, which was the first of its kind in the world on a domestic level, which was put together by Bosnia-Herzegovina. So maybe if you could give a few words on how that worked.
So, and also another question. Yes, sir? So we need your assistance with mic. Mm-hmm.
Who'd like to?
Oh, okay. And also the question from the woman.
Okay. A very good afternoon. My name is Goran Batic. I'm also with ICMP. I have a question for Katarina, Lona, and Tatiana. Given the notion that what you're doing at RD4U necessitates such large outreach programs, one would really wonder what is the relationship and cooperation between the RD4U and the Ukrainian civil society organizations in Ukraine? And also, how do you see the role of Ukrainian organizations in the diaspora, such as in the Netherlands? Because there are entities, and I imagine they would have so much power and they could offer so much support to these efforts. Thank you.
Thank you.
Good afternoon. My name is Olesa Zayas, and actually Goran just voiced my question because we are representative from NGO here working in the Netherlands, in Amsterdam, and we are part of your coordination platform. So I also would like to, but the question was already there, but then I will ask you another one, which is quite practical. We are going to the fields and working on shelters, and we are meeting people with all these claims, damages, and losses. And the recent problem that we faced is that register of damage opened two categories. One is death of immediate member states, and another one is missing person from immediate, also like family. And the guy whom we were speaking about, we are not giving them advices, but we are consulting them how to go and to apply, how to submit their claim. He said that my son, he was a military, and people who served with him saw him being killed on the field, on the battlefield, but as usually as it's happening, the body was not retrieved, and there is a very also low possibility of being retrieved from there. So I said to him that in the future, it was a month ago, in the future you will be able to submit one of the claims, it's a missing immediate family, but for him, it was morally very difficult because he understands at that moment that most likely he was killed already. So maybe you can just comment about it and give your opinion. We are, as I said, no advice in how to do because it's very personal and families should decide themselves what to do and how to act. But for me, it was also very morally difficult, and maybe you can comment it. Thank you.
So, who would like to address?
I'm honored of microphone.
Dr.
I will start with response on that question related to definition of missing persons in the BH law. When we are first, Bosnia-Herzegovina has experienced so often situation to be pioneer in many things, although maybe today also in some circumstances, and we also where first country adopted law on free access to information, and that tool is very relevant for searching of missing persons. and why we decided to define missing persons in the law, not enforce disappearances. First, it was a requirement of family, and consultation process of families brought us to that solution. Second, approach in the drafting process of law was humanitarian, to provide first that what I said, that victims are asking truth, they are asking recognition. The disappeared person during conflict, because conflict is extraordinary situation, war, that person who disappeared, it is missing, and some people are suffering. We don't know at that moment circumstances under that person missing, but there is need, there is also obligation of state to discover truth on that what happened, regardless of that what are causes of disappeared that person. If we are focusing only on forced disappearances, we always asking next, first missing, and second factor, involvement of state authorities. But it is not only state authorities who participated in the war. There is also different groups under control of state authorities, but also some groups which are created by themselves without control of states, but they also have power and so on. Different actors are involved, and definitely to conclude it, missing persons is humanitarian approach. It is the best approach to provide, to be sure that any person who disappeared will stay out of protection. But in further steps, you can create distances and distinctions about causes and so on. If I'm now, again, after such long period since law has been adopted in position as lawyer, to draft again law, it will be the same approach. There is no chance that I will change. Although after that, I have been in many, many countries in mission with working group of enforcing voluntary disappearances, including Chile, Mexico, Sri Lanka, East Timor. I will suggest any country to use that humanitarian approach, and definitely humanitarian, and after coming human rights to ensure, and on the end, justice. And in justice, you can, when we are speaking on the responsibility, who is responsible for enforce this, if that person was enforced, disappeared, we are asking somebody who will responsible for that, who will be guilty in court process and so on. But it's third element, but before that, humanitarian approach, discover truth on disappeared person. Also, I would like, there was one question during our coffee break related to treatment of disappeared persons from temporarily occupied territories. Should they be registered or not? I would like to remind us on period in 2017, I was first time in Ukraine related, it was exactly before was adopted law on pensions, and there was the big debate that it was in my country. Do people who are living on temporary
in the last row about coordination and cooperation between Ukrainian civic society and the Register of Damage for Ukraine, because all of our organizations, they are members of the coordination platform, so we can share with you our experience and some insights.
Я хотіла ще прокоментувати.
Yes, I would like to make one other commentary, but then, okay, let's speak about this. Zmina, just like any other civic society organization in Ukraine, is a part of the civil society in Ukraine. And we are developing our coordination with the register, with the Register of Damages. I think it's very important because there are CSOs who work directly with the victims, and they're very conduit of ideas from the victims and their families, and this is how we also communicate with the register as a conduit of information from the victims. Also, we may help with information. The register itself has a very small number of personnel who work in Ukraine, and they are underrepresented in the regions. Therefore, they can do more once they cooperate with the CSOs, and it's important to take part in this communication and coordination. It's a process. Process means waiting. We need to wait until the register suggests that proposes that we can communicate, and whenever a category is opened up, we always spread information about a new category using our own capabilities. What else? It would be good if in this coordination platform we could discuss some problematic issues. For instance, what is the role of certificates that we recommend to be used in the work of the register, and how to use these documents? Because CSOs in Ukraine, historically speaking, starting with 2022, they have been documenting many witness statements. We have testimonies. We have a plethora of testimonies. And in some categories, these facts are being registered by the state. For instance, there is a register of the IDPs, there is a register of the missing persons that will be populated with the testimonies. But once we speak of the civilian and military people who have been deprived of liberty, in the case of the armed aggression, there we will not have as many people who approach us, because the state procedures are not transparent enough to populate that register with information. But CSOs know about people who have been deprived of liberty. However, the state has not corroborated that fact with regard to that category. So it's important to open a possibility to populate this registry with information about people deprived of liberty without having a certificate. Right now, only those cases may be filed with the register where we have a certificate of a person gone missing, but in the future it may change. And we have a question to the national mechanism of fact finding with regard to the category of people deprived of liberty. We need to develop a mechanism of submitting claims there as well. So there we need a special document. We as CSOs may draft such a document, and this is what we can talk about with the register using the coordination platform, and this is what we would like to talk about indeed. Now, how about submitting documents from the occupied territories? It's not that the discussion is going on whether if they can submit, it's technically how to submit papers if you are in the occupied territory. This means that we need to think together what to do in the occupied territories. There we have from 3 to 5 million people. Some of them will definitely, absolutely definitely, are subject to the register. So we need to think how to give those people a possibility to file their claims. This means that somewhere in the register there will be information about those people and what has happened to them in the occupied territory. So to sum up, we may communicate a lot of information to the register. We are a provider of information because we receive information from our people and from our beneficiaries. But also we're ready to take part in discussions on finding solutions for the problems that are already there or will appear. Because some questions, some issues are ongoing issues and they need discussion, so we are there to work hand in glove with the Register of Damages. It will take a lot of time. This process will take a lot of time, and therefore we need to be very consistent in our work.
That were mentioned by Alena, and maybe give a little bit of background information about the coordination platform that we already heard about from the audience and also from this stage. So indeed, the team of the register is represented not only in The Hague, but we also have a Kyiv office. And I would like to say hi and also thank you to the Kyiv office for all their work, and I'm sure that they're also following this event online. And indeed, the core function of the Kyiv office is to conduct outreach activities. And recently, at the end of the last year, the coordination platform with civil society organization was created in Ukraine. So basically, at this stage, I am representing the register, but also I have partners from both sides of my hands that are also supporting the work of the register here in The Hague, in Ukraine, and outside all over the world, because the Ukrainians, because of the full-scale invasion, they are now living all over the planet. And going back to the question regarding the sensitive categories about the missing of immediate family member, also indeed, as of now, we have 9 categories that are open for submission of claims. And as was mentioned, one of them is the death of immediate family member, another one is the missing of an immediate family member. And as you've mentioned, it's a devastating fact in itself that there is no more of loved ones either we don't know where he or she is, or we are aware of the fact that he or she is dead, but we still cannot find the remains of that body. And in the register, it's also a very devastating story as it is. We started receiving claims in the category of death of immediate family member, and me and my colleagues, team of the register that is dealing with reviewing and processing of the claims, we're reading the stories of lives and how lives were actually taken by this war. But at the same time, we're standing at the side of law. We're trying to be unbiased. We're trying to make fair and just decisions. And in this case, we all understand this is a mass claims process. So basically, the decision to submit a claim, it's on the side of a claimant. And considering all the sensitivity of these categories, we're just hoping for, again, for our partners in civil society to be, so to say, our hands in communication with the claimants, with the victims and survivors of this war, and to inform them about the possibility, about the role, the function of the register, and how the register can actually help in acknowledging this loss, and also at the end receiving compensation for this loss. But once again, as it was mentioned during this discussion, sometimes, not even sometimes, I'm also a representative of a survivor, I'm also a victim of this war. I understand how important memorialization is. And that indeed, sometimes it's even, not sometimes, it's more important than receiving some set amount of money for your loss that you sustained. Thank you.
So before Dr. Baranovska jump in, I would like to ask our panelists to prepare their final remarks, because we should conclude this discussion. But as I see, Mr. Dobroserdo is also willing to address this issue.
Можливо, я поєднаю
Maybe I will put it as my final words, and I will have some commentaries. So, as for the further development of Ukrainian legislation with regard to the missing persons, there are many aspects, legislative aspects, that need to be taken into consideration. We need to improve some things. Once I first saw the law, when I was a law enforcement specialist, the first law, at the first glance, was for me very strange, progressive, very European. It was written in the style that was new to me, and I did not know how to do things in line with that law. Practically speaking, at that time, I didn't know how to enforce the law, but now, some time have passed, and I see that that law was really well written. And I see now how much work could be done on the basis of this law. So we need to give legal help to the families of the missing persons free of charge. So there is a law on free legal services, and there is this need and there is this demand for this type of legal services. Now we are cooperating with the CSOs. CSOs give a lot of legal aid free of charge, but we need to fix it in the law as well. Next law is we need to sort out many different categories. POW, information about being pre-POW from other sources, or the category of a missing person. For instance, let me give an example. I have a soldier. He's a missing. His brother filed a document to be deferred from the armed forces because his brother was in the armed forces and was taken as prisoner of war. But some state institutions say that one category excludes the other category, and therefore we need to sort these terms and notions out. So we need to have a law that will clarify the legal notions, legal definitions. Now, we're all moving towards Europe, and right now we are moving much faster towards the European Union. This is exactly the civilization we belong to. Now, a very simple question. We need to have an official opinion that may be drafted by a specialist from a third country. And we need to treat it as a piece of evidence in Ukraine. So if there is a foreign expert drafting an opinion, it's important for us to be able to treat it as an evidence. But if we have a very large number of expert opinions being drafted in order to identify the victims, we need to work just like other European countries do. So, for instance, if a Polish expert drafts an opinion, that it will be treated in court as a piece of evidence. If it's a Czech specialist, it will be treated in our court as a piece of evidence. evidence. So we need to change the current situation. We need to address this issue. We need to be sure that foreign experts' opinions shall be treated as evidence in Ukrainian courts. That's very, very important.
З громадськими об'єднаннями.
Our cooperation with the civil societies and the people of missing people. You know, the army of families is very important because it can give more than any other results of whatever is going on. So we learn as we work. There are a lot of things that we do, that we are motivated by the families. Very often they ask the questions, you know, we have problems with this or that. And it's not criticizing. It's not like, you know, we have a good specialist, we can help, you know, he will give you an advice how to do it. So we have united our efforts. So we do have conversations with the CSOs. They said, you know, we all our life we have monitored law enforcement is doing wrong. So now it's quite strange that we sitting now together, resolving the situation and do certain things together, how to help our people, our POWs, etc. That we are working together, it's very important, and that gives a good result. Dr. Baranowska, please.
This definition issue that has been brought up here a lot, but those are my final remarks, so then I will pass on. What I really thought was very important is what Jasna said, that this humanitarian approach for the search is particularly important in those large contexts where a lot of people went missing and we do not know what has happened. So requiring families to categorize a person before filing a case is illogical and inhumane, right? So we just want an easy way for families to apply. At the same time, so this is the search, and I don't think there's logically another way to do it than really in an encompassing way, all missing persons, with, as you pointed out, the broadest possible definition that you can address. So this involuntarily is really all that we need to know, right? Kind of that should be sufficient. But the search should be parallel to investigation if there was a violation. So this can never be approached just as a humanitarian approach. And here I think the ICMP has been always consistently reminding that this is really the way to go, that there needs to be both search and investigation, and they need to be conducted together. And the Committee on Enforced Disappearances, so this is not the body that I belong to, but as you have mentioned, Ukraine has also ratified the convention and recently was at the committee also within the dialogue. They have adopted guidelines on the search of missing persons, and one of the points is that the search and the investigation should be conducted in parallel. So both are necessary. So we are doing both. And this, I think it has been repeated a lot, but I would like to highlight that. With regard to both, the families should be at the center. So it's not that families are just involved in the search, or families are just the witnesses involved in investigation. They are the ones involved in both. And this is really how we need to think about both of those processes that might sometimes be going in different direction as well, right? So we could also have a person that is only sought for, but that we do know no investigation will be conducted for, and others where both will be happening. And kind of that brings me a bit back with the families to your question. And I think that's a question I don't have an answer to. So it's so difficult to require people to decide, do I want to qualify my child as a person that has passed or as a missing person? So the only way kind of to address that is to give them a possibility as flexible as possible and to follow the voices of the families of what they actually want. And this is our role as experts to really bring that voice up and say, we need to create frames, we need to create spaces, and we need to adjust them to what's needed, as you said, exactly, precisely in this context. So what might be needed in Ukraine is something else than what is wanted by families in other contexts. And that's what we are here to find out. And on a positive note, I found it actually very amazing that we are here debating reparations with civil society, with international actors, and with actors from the national authorities. I don't think that that's a regular way to address things. And it's really the way kind of to achieve success and also to be thinking on a long-term perspective. So this is not only the search today, it's not only, of course it is the search today, of course it's releasing the people today, but it's also supporting their children, their wives, their husbands, their parents for the years to come, and their communities as well in the memorialization of what's happening.
And now I'd like to pass the floor to Alona, because as I know, Alona should leave us because of the participation in other events, so...
Я хочу насправді продовжити.
What I want to do, I want to continue. When I said we were developing the draft law, because I was participating, we didn't want that law enforcement agency would be in the system, because we thought the humanitarian aspect is the most important. And if you are not a part of the law enforcement, then you could efficiently conduct this activity. But life showed us that having the representatives of this system and the system of Ministry of Internal Affairs was a correct decision. So the legislation is what really represents reality in 2022. It was important that this was a part of law enforcement. That's why here we can change things depending on the context, and we can view the legislation as something that could be done. It's important when the government, sees when there is a need to change and we can amend something. Then the people who suffer it have to be a part. In Ukraine, we do have many categories in this regard, so we need to move in this regard. We need the system of support of these people, and also understanding that it's not limited to financial material assistance. We need a whole system, a holistic system at large. And it's important to talk about the things that are not compensation, because we talk not only about finances, but sometimes we call it symbolic justice. We don't know if in court, we will get this justice, because we, believe that the judges and courts can solve everything. But historically, we know it's not always the case. That's why this, to have a memorizing this, it could be the important way ahead. We need to work knowing that this is a long period, and we will have work to do for many years to come.
Miss Tetiana Katrichenko.
Definitely, it is very important when we are mentioning memorialization as part of reparation. Don't forget that part of that is history and education and changes in curricula in school to avoid a repetition. And we so often forget that, but definitely it is very important to start earlier. We late with that process, and therefore maybe we still have problem to find finally peace, not only because of global circumstances. I'm so glad that representative of Ukrainian authorities mentioned that process, that they understand that they are in the process, but there is still a big space for further development, taking in consideration the obligation to changes in criminal legislation, first of all, to take evidences provided by experts, foreign experts, and so on. It is significant progress in importance, recognition of further needs. But that's what I can conclude from this morning session, that there is general rights, general provisions for all victims. That what must be provided for, starting from recognition, victims of rape, victims of sexual violence, missing persons, victims of mines, and so on. All what should be provided, but after that there are particular obligations towards each of those categories, and today we mentioned and we have focused on missing persons. First of all, for them it's the most important truth, and to discover fact about that what happened. And next, what is situation when we have a multiple status of victim, as was mentioned case if it is soldier. And what relatives want to enjoy rights as relatives of missing persons, as relatives of missing soldier. We had that situation in Bosnia and Herzegovina. A major part of families decided to enjoy, they had the right to make choice, to decide rights as relatives of soldiers because they are very higher. A very small part of population stayed with that, only with status of missing persons. But it is very important to give option for choice, but that does not exclude obligation to provide those general rights for all. Only the difference is in this stage of amount of money which they received, because mobilized soldiers, it is obligation. They were there because of duty. Missing person can be accidentally, can be taken from home, and we should recognize that by additional value, but not to give only money because of status, but to give additional benefit because of that status.
Thank you, Dr. Yasminka. And now, Ms. Tetiana Katrichenko.
There is one important thought that I think we didn't talk a lot today about it. We talked that in Ukraine, we still have a war. And during this active phase of war, we have to arrive on decision. We do not have time to wait that the conflict will end, because we don't know exactly when it's going to end. That's why it's important, and we talk here in general about civilians and military personnel, but during this conflict on the battlefield, a lot of people are dying. Soldiers are dying, and we know that in Ukraine we have places where there are mass deaths of people. And for us as civil society organizations, the task is to document it. We need to know where do we need to look for our soldiers. It's important because if conflicts would last only for a couple of months, like for example, in Kiev region, occupation was more or less 4 months, we would know more or less where we can find the remains of civilians, of military personnel. But Popasne in Luhansk region, still in spring 2022, a lot of soldiers, especially from the 24th Brigade, disappeared. So we need to know all names of the people who were killed there. We need to know all these details so the justice will come sooner, the truth will be known sooner. So Ukraine can right now go into these gray zones, let's say, and take the remnants of the soldiers that we consider now as missing persons. But as far as we know, the Russian Federation, it's not strange to us at all requests of Ukraine, they say it's impossible. Practically, the Russian Federation blocks this process of search and identification of Ukrainian military. A lot, of course, it's up in Ukraine, but we do need the assistance from our international partners that during this conflict that still is waged on Ukraine, the work should not stop. We should be able to continue this right now as well. Thank you.
Ms. Katarina Pisocka.
Thank you. quick and straight to the point, and I think I will build upon the observation that was already made about this unity, that we're all working together, the expert, the civil society, the government of Ukraine, the international mechanisms that is created for reparations. And I think what also Tatiana has just mentioned about this unity in the ongoing conflict, it's quite crucial to actually to save this unity, to maintain it, and that will help us to get to the final point of compensation, again, recognition, memorialization, and actually ensuring all the rights of the victims that suffered, and also survivors of this war. Thank you.
Thank you. Franziska?
It's the very final word. What I take with me from this is really how much has happened already and how much is underway for the missing persons from ICMP, with a register that is nationally there, that is now internationally there, and how much understanding there is for so long already. So it's really amazing. I'm very impressed to hear that, and also to see the input that is there in now moving forward, really with respect to that specific question of the missing people. Now, there is a lot of scope for reparations for the families, for moving forward in that respect. So that's the other issue I take with me, and I think we all take with us, that it's going to be a long road, set by so many speakers, on which we are all together. And I also see some room for the Trust Fund for Victims, and I think there is a coordinated approach very necessary with the government in the first place to achieve reparation beyond those families of the missing, for all the different categories that are there already. So so much work has been done, and so much can still be done, I think, very much with the support of the international community that is really required to support these efforts, they're so unique. It's amazing what is already happening while this conflict is ongoing, and it's due to the Ukrainian government and civil society that we are there. It's amazing. Thank you.
Thank you, dear Franziska. So thank you, distinguished panelists. Thank you, dear audience, for your activeness, also for all of your questions. Just to recap, all of our speakers mentioned this need to cooperate, to coordinate our activities, also to have this unity. And I think that we also should have the sustainability of our efforts, and to understand, as Dr. Baranovska has mentioned, that we will play a long game. We should be prepared, we should understand all needs, we should understand the situation. As Alona mentioned, we should build the system regarding the situation on the field, taking into account the real situation and not just experience from other states or from international practice. And of course, I really like this idea that Ukraine needs not only some financial assistance, technical support, expertise, but Ukraine itself has already this possibility to share our own experience, which we have now during the armed conflict, during this open stage of the Russian aggression, which is maybe have this sign of uniqueness, like it is the same with the register of damage. So we are living historical moment, and I hope that all needs of families and also of survivors of enforced disappearances will be met. Thank you. Thank you. So we can continue our discussion in more informal way during the coffee break. Yes?